You guys are freaking amazing. You guys have no idea. I appreciate you guys so much. Yeah, I'm over it. I'm really over it. But I made a promise. I would see it through. Oh, I am, Amy. Thank you, sister, for the populars. I was telling everyone yesterday that I slept like a baby. I slept so good. I think that was just my body's way of being like, you're old. Chill. That's a perfect statement. Bree's lawyer is a clown. I agree. Rhonda, hello, my love. It's this is literally what my home looks like right now. Rain. Okay, we are flooded. Thank you, sister. It's beautiful. Mama Rachel, hello. Hello, Rhonda. Life of Steph. Day has been good. Jordy and I had the absolute best day today. My glasses are dirty. I came home and I got some stuff done. I even ate a little bit before I came on, and I got like the dishes done, just little stuff done around the house before I came live. I feel so productive. It actually was just a stall tactic because, again, Western. I'm just sick of this. But I promised y'all I would see it through. I'm going to see it through. But again, I do want to say this again. I know it's none of you guys. Brandy, you guys are so amazing. Hey, people are garbage. 640 people or what is that called? 640 daily heartbeats. You guys are the best. In Tennessee, yeah. Listen, they always say that Washington is the rainiest city. Why are my eyes watering? Or the rainiest state. It really hasn't been, at least not for many years. But we cannot catch a break. We cannot catch a break. It has been absolutely nonstop. I think in the past like 3 weeks, we maybe had like 2 days. And I'm not talking like little rain. I'm talking like downpour. We had a bomb cyclone. I didn't even know what that was. Okay. Tasha, I'll send you some. Give me your address. I will gladly send, and I love the rain. I will send you some. I will tell you though, at nighttime, it's heavenly. I sleep so good because the sound, it's so relaxing. Lizzie, were you registered and you didn't get one? It was 70 today. Oh no, that's terrible. 70? No. In January? Oh no, that's terrible weather. I hate the heat. Absolutely hate the heat. Okay, let me find. No, not the minute order. Silly me. 80? Where the hell do you guys live? Oh, okay. Yeah, when I do events like this, like where I'm going to start and then go, I try to do them where you guys can register for them. AZL, that's why. Didn't mean to snarl. I just hate the heat. In Florida, yeah, I can never live. That's crazy. In Texas, to 80 degrees, that's crazy work. 25 what? Hello, Tanya. 35 here. Oh, degrees. Hello. That's what we're talking about. That is crazy. It's hot everywhere. No, I don't know how hot well, let me look. Now that we're rigging up, and then we're going to dive in and get this knocked out. I'm ready to talk about something else. No offense to 2K or Bree, but I'm ready to talk about something else. It's 42 here. I hate it when they toy with my emotions. On Sunday, it has rain and snowflakes, but the low is 41, the high is 46. We're not getting snow with 41 degrees. Shut up, weather app. Brooke, you're speaking my language. Minus 19. I'll take it. That's my kind of weather. Stupid app just likes it. But then we got 1, 2, 3. Oh my god, then we have 5 days of no rain, you guys. We need that. Bailey's here. Yay! Shout out to my lovely assistant, Bailey.
Dude, I'm so ready for it to be over too. And I think it's also because I'm like, oh, we're getting into Breeze, and I just know I'm going to be so irritated with all of the lies.
Right. I agree. Oh, let me say really fast, I just did a video on this too. Ouch. Because I've seen this video so many times and I haven't hardly been on today about the Zoom thing. This eye keeps watering. I highly doubt that 2K leaked. What would 2K get to leak the Zoom? Right, what does he get out of that? Absolutely nothing. One. Sister! Not a sister. That's my daughter. Hi, Jasmine. I saw Beth's name at the same time as you. What the hell does he have to get out of it? And it's public knowledge. You guys, courtrooms are public places. Anybody can go. Please don't go. Let them have their privacy, right? Reading their court docs is totally different than showing up. And again, I don't know who did it, but I really feel like it was out of malice. Because if you're just leaking information, we would have never known Santos was kicked out of the courtroom and a couple other things that happened. That's just crazy, right? I truly feel that family courtrooms should be closed. Hi, Chastity. But nobody asked my opinion. But don't go around blaming John like he did it. Anywho, that's all I got to say about that. Jasmine, hold on. I think your dad's trying to off me, Jasmine. I cut myself twice today doing the dishes on the knives he got me. Just wanted to let you know that. If I'm not there in the morning to watch the baby, your dad took me out. Want to let you know. She's like, God damn it. Okay, are we ready, dear?
Yes.
Okay, we're doing the Declaration of Respondents Council. Lodging Part 1, is that what we're on?
Yeah, I'm on part 1.
Okay, Exhibit A. Court reporters certified 8/26/25 transcript. So we're going to go down. Thank goodness, at least we get to skip a couple pages. Okay, so if you guys have not done this before, hey, make sure you're following both of us. Whenever I'm reading, I'm the judge and both witnesses, and I'll tell you who it is that I am and Miss Bailey.
I am Bree's attorney, Miss Fonseca, and John's attorney, Miss Budnick.
Thank you. Okay. All right, so appearances. Well, we don't need to do appearances. That's fine. We know who we are a lot. Everybody was there. Okay. No, you guys, this is the transcript. What did my daughter say? This is the transcript from, it wasn't user error, Jasmine. Don't be a daddy's girl and take dad's side on this. They're just really good, sharp knives. Jasmine, go do something. And who agreed to her with her? Anyways, you guys, this is the transcript from August. This is the transcript we've all been waiting on. This is the trial. The transcripts takes months to come out. We won't get a transcript for January, probably till they're in their court thing for April. So it takes a long time, but Auntie Beth agrees. Go figure. Beth, Auntie Beth over here agreeing with Jasmine. But this gives us a lot of context of what was going on. Okay, so I'm going to stay out of the comments. I won't be able to answer your questions. Thank you guys for gifts. I'll do all of that at the end. Just know that I love you and I appreciate you guys being here. But we got a lot of reading to do. So here we go. The judge. Back on the record on the Giese versus Olson matter. Appearances, please.
Then Miss Budnick. Good afternoon, Your Honor. Taylor Budnick for the petitioner, John Giese. He is present at counsel's table. Then Ms. Fonseca, good afternoon, Your Honor. Lindsay Fonseca for respondent Brianna Lynn Olson, who is also present at counsel's table.
Thank you all for your indulgence with the technical issues in the court. Okay, a couple of quick housekeeping matters. I understand there may or may not again have been filming in the hallway in the court. Does anyone have anything they want to talk about on that briefly? Anybody?
Then Ms. Budnick, there was chat snaps that I saw from the respondent's boyfriend that were posted in the hallway of the courthouse yesterday after the hearing concluded.
I know he's not here today. Is that correct? Really fast, respondent is Bree, so she's talking about Santos in this situation. Okay, sorry.
And then Ms. Fonseca, correct. He's not here.
I mean, look, this is court at some point. I'm just going to start calling people in and we can do contempt proceedings. Oh, she's spicy today. I don't want to do that. So I advise you all. I understand what you do for a living. I get that. I understand that's how you make your money. I thought my request was a relatively simple one. Don't film inside the courthouse, film outside. So I'm going to state that order again. And if it happens again, well, the court may have to go. May have to elevate it to the next level, which I don't want to do. So please remind everybody that that's with all of you. There's understanding that individuals were with Mr. Giese when they were told they didn't need to. They weren't supposed to film. We haven't heard any indication of them filming. So I appreciate that. But that works for both parties, okay? Second issue, just to make this, it sounds like everybody can do tomorrow afternoon. I had an opening. So just in case, we reserve that potentially for closing arguments and things like that.
Then Miss Budnick, that's perfect.
Okay, some housekeeping things. No speaking objections anymore. Thank God. Kayla, thank you so much, love. Thank you. You guys know I love a first gift. Sorry. I always have to shout those out. No speaking objections anymore. The objections are relevance, foundation, hearsay, lack of foundation, speculation. Those are all legal objections. And if the parties disagree with the other parties, they can be heard. Please do not argue with the court. Once I've made my ruling, we're done. We've moved on. If you don't agree with my evidentiary ruling, you have your appellant rights. I might have gotten it wrong, but we're wasting a whole lot of time on this back and forth, and my fear is we're going to run out of time, okay? So when we were last here, I guess Mr. Giese was still on the stand, and you were, like, in your cross-examination / direct, correct?
Then Miss Fonseca, I said at the end of yesterday that I could be done with him. I think we were supposed to pick up with Miss Budnick's redirect.
Okay. And is that where we are?
Then Miss Fonseca, yes.
Okay. Mr. Giese, do I need to re-swear then? The judicial assistant, yes, Your Honor. The judge, let me re-swear everybody. Miss Olson and Mr. Giese, will you both raise your right hands? John, yes, ma'am. Judicial assistant, please stand and raise your right hand. You and each of you do solemnly state that the testimony you may give in the case or the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God. John, yes, sir. Respondent, yes. The judge, go ahead and resume the seat, Mr. Giese. And then John says, yes, Your Honor.
Then Miss Budnick, thank you.
John Giese called as a witness on behalf of the petitioner and having been first duly sworn, was examined and testified as follows. Redirect examination.
Then Miss Budnick, okay, John, yesterday you were asked about social media content that you had filmed with the respondent's boyfriend, where you guys were mutually insulting each other. Do you recall that?
Right. Yes, ma'am.
How would you describe that specific type of content? The Miss Fonseca, objection, vague as to time that we're asking about.
Well, I think specifically because he talked about two different periods. He talked about before when, I guess, they were on better terms and then after. So I think Ms. Fonseca's point, if you can frame it in that relevant time frame.
And Ms. Budnick, sure. So prior to March of 2025, how would you describe the mutually insulting content that you and respondent's boyfriend Santos engaged in?
Friendly banter.
Okay, at some point, did your dynamic with Santos progress from friendly banter to something different?
Yeah, after the March 25th incident.
Okay, and was there anything specific that happened between March 23rd and March 25th that changed your perception on whether or not Santos was a threat? The Miss Fonseca, objection, leading, and relevance.
Overruled. And then John says, when he was holding my son and said he was going to make a diss track about me, when he told that to my son's face, and he also
Then Ms. Fonseca, objection, hearsay.
So this is the judge. So hold on. Okay, go ahead. Let me hear your response.
Then Ms. Budnick, I was just going to say it's for the effect on the viewer listener, which is how my client was affected by this, not necessarily if it was true.
Well, I think it potentially can serve. My sense is it's the words themselves that are serving as the purpose, potentially for this DVRO, potentially for another. Whether it's a civil harassment, they're not being offered for the truth. The issue is whether or not he was going to make a diss track as well. This individual believed that, so that's overruled.
Then Miss Budnick, right, okay. And do I have, for everybody, I have the transcript of my Exhibit 81.
Great.
And I would like to show Exhibit 81. Then Miss Fonseca, and I would say objection, relevance to this one as this one too. Then Miss Budnick, so this is a video of the respondent's current boyfriend with the minor child during that March 23rd to March 25th period where W was in Los Angeles. Then Miss Fonseca, objection.
Judge, do you have a response regarding the relevance?
Then Miss Fonseca, objection. Well, objection. One, counsel's testifying as to the date because she said this is a third party's video, and two, this is not a CHRO, as the court made clear yesterday. This is not an action between dad and my client's boyfriend. My client is not in this clip at all. Hold on one second. Good night, baby girl. I love you. And then Miss Budnick, the minor child is in this clip, and it speaks to the reasons he has concerns. Then Miss Fonseca, that sounds like custody and visitation.
Okay, let's do this really fast. For anyone who's... Thank you! I don't know what that was, but thank you. Anyone who's confused, Miss Budnick is John's attorney. Miss Fonseca is Bree's attorney. I always remember because I just call Fonseca Miss F because she fills in a lot of this stuff, and that's how I remember it. Just wanted to let you guys know. Okay. Okay, let's do this.
Then Miss Budnick, I can ask him another way.
The judge, I will allow it to be played briefly. In terms of the relevance, though, I agree with Miss Fonseca but in some ways, I think it may support her argument initially that all that there has to yet been any... Wait, what is she trying to say here? Initially, that all that there has to yet... I'm reading word for word what the judge says. It don't make sense. But anyways, that there has to yet been any proof that Miss Olsen directed any efforts by Santos. I don't know his last name towards Mr. Gacy. So I'm going to let it in. It may be a limited relevance, but at least it may even support Miss Fonseca's argument as to a lack of evidence. So let me take a look at it.
Then Miss Budnick, okay. And then into questioning. So John, who is depicted in the thumbnail of this video?
That's Santos and my son W.
Okay, I'm going to play the video. Oh wait, I'm sorry,
Oh, sorry.
And it says, whereupon a video recording was played.
Okay. And then the judge says, okay, so I will note that was a video of, I guess, what appears to be Santos. He has a hat on. I didn't recognize him. So I think all the parties, they don't dispute that that is Santos. And W is in the video. It does not appear that Miss Olsen is anywhere in this video, nor were there any sounds of the sounds or the other term, crosstalk or any of that other testimony. The fact that Miss Olsen was somehow or other directing Santos to make these comments.
And Miss Budnick, what specifically, other than the comments from Santos, what about the video concerned you? And Miss Fonseca, objection, calls for a narrative.
I'm going to overrule it. And then John says, "Can you repeat your question?"
Sure. Other than the statement from Santos about the diss track, was there anything else about this video that concerned you?
Yes.
What?
Where was his mother? Why is W alone with this stranger going in a different part of the house where nobody else is at? W is scared. W is confused. W doesn't know him.
And how could you tell that W was scared and confused? And Miss Fonseca, objection, lacks personal knowledge.
And then he says, first of all, I know this. He says, because I know my son. How would it be lacks personal knowledge when John has him all the time? He would be the one to know. But anyways, that's what he says.
Yep.
Because I know my son.
And Miss Fonseca, and relevance. This is custody visitation.
Okay.
Then Miss Budnick, I'll move on.
That part is irrelevant. You're right.
You had also testified yesterday about an incident on that where you said that Brianna and Santos had come to your hotel in California and threatened you. Do you remember that?
Yes.
Do you recall the date of that incident?
June 20th.
Okay, and you were asked how you knew they were at your hotel. Can you describe how you knew that they were at your hotel? The Miss Fonseca, objection, asked and answered several times yesterday.
Overruled. And then John says, they were making videos outside of the hotel that we were staying at, and they were asking where we are at. Where we at?
The Miss Budnick, okay, and then I have out Exhibit 74, and I have transcripts.
Thank you.
The Miss Budnick, and I'm going to play for you Exhibit 74, whereupon a video recording was played, and then Miss Budnick, and then John, what is the name of who does this ChapSnap account belong to? Then Miss Fonseca, objection, lacks personal knowledge. It's not his.
The judge, yeah, where's the foundation?
Then Miss Budnick, okay. And then the question, oh my goodness. And then Miss Budnick again, can you tell me the name of the account that posted this snap?
In the top left corner, it has the name Santos and Bree, so it's their joint account. Thank you guys.
Okay.
Where are we? Okay. So many foundation issues there, or foundational issues there.
Then Miss Fonseca, I know. Then Miss Budnick, I can move on.
Okay, well, hold on. Just so everyone knows where the court is coming from, my sense is you didn't subpoena any of the foundational TikTok records in terms of the custodian of records at TikTok. Is that correct?
Then Miss Budnick, with respect to what? This is with ChapSnap, but
Okay. So ChapSnap, okay? Because in order to prove that an account that says to Brian Santos actually belongs to Brian Santos, there's different ways of doing it. You can subpoena the records of TikTok and ask for, look, they do this in search warrants all the time. And who is the URL? Who is what phone number is connected to all that? And then someone can say, well, that's Bree's phone and blah, blah, blah. Or there's other things, the testimony account, that this is where I frequently see Brian Santos. So she objected. The main thing I will get from here, I didn't see in that video Miss Olsen anywhere in that video.
Miss Budnick, I will get there.
Okay.
Thank you.
So, well, no. But my point is, it goes back to the larger issue. This is not a civil restraining order civil order action against Santos. This is a DVRO against Miss Olsen. So if the basis of saying Miss Olsen was involved in that threat because it's an account from Bree and Santos saying you're on infirm evidentiary hearing.
Ms. Budnick, I understand.
Okay?
John, did you see any content from Bree that acknowledges that she was a participant in the June 20th incident that we just watched the video about? Then Ms. Fonseca, objection, leading.
Judge, yeah, that's pretty leading. Are you going to show him something?
Ms. Budnick, I do.
Why don't you just show him something?
Then Ms. Budnick, I have Exhibit 73, so I will get you the transcript. Then Ms. Fonseca, and I would object on the basis that if it's going to be a personal knowledge objection. I already know. If it's a video of Brianna, then Miss Budnick, and I can ask her.
Judge, hold on. Okay. And the personal knowledge being what?
Then Miss Fonseca. So the personal knowledge as to why she's saying what she's saying. This is not her saying like, I was there. I'm admitting to anything.
Okay, there's a difference between weight and admissibility. The last one potentially went to admissibility to say, because it says Bree and Santos, therefore it's her account. But if she's on video saying something and saying these phrases, that to me goes to weight, not admissibility. The argument would be, yeah, Your Honor, she knows she was part of it because she admitted to it. And you infer what she's talking about. So that's overruled. Let's play it and we'll go from there.
Then Miss Budnick. Okay. And then, John, our Exhibit 73, what was the day of this recording?
June 21st. And the judge says, how do you know that?
Then Miss Fonseca, objection, lacks personal knowledge.
Did she just object to the judge? That was the judge
Yeah.
that asked the question, how do you know that? She just objected to the judge. Oh my God. Okay, sorry. Go ahead.
I didn't even put two and two together till you said that, and I looked up and I was like, oh, yeah, she did.
Well.
Then Miss Budnick, how do you know that?
Because it was posted the next day. Then the judge says, how do you know? Wait, but how do you know that?
Then Miss Budnick, is that the date you saw it?
Yes, ma'am. The judge, okay.
Then Miss Fonseca, I would object on leading to most of these questions we've heard so far.
Okay, it's leading, but it's the larger issue with all of this because my understanding is you can record something sometime previously, but that doesn't necessarily mean that that was the day that it was posted. So, short of having the metadata of the actual recording, all he can testify is, I saw this posted on.
Then Miss Budnick, understood.
And we'll go on from there.
Then Miss Budnick, okay.
Whereupon a video recording was played, the judge says, what date did you see this? John says, on the 21st. The judge says, of June? John says, yeah, yes, ma'am. The judge says, okay, he can testify to that.
Then Miss Budnick, okay. John, you were also asked yesterday about a group chat called 2K Private Investigators. Are you aware of what platform this group chat utilizes? Then Miss Fonseca, objection, asked and answered yesterday. Then Miss Budnick, he didn't answer that.
The judge, I don't even remember that, so please go ahead. And then John says, just iMessage. It's not social media.
Then Miss Budnick, okay. And it's an iPhone. Is it an iPhone text message chat?
Yeah, yes, ma'am.
And do you know who the members of this chat are? Then Miss Fonseca, objection, relevance.
Okay, am I seeing another exhibit? Hold on really fast, Bailey, because I haven't read this ahead. If by chance, when we're going through, if by chance it does state any names, just don't say them, okay? I don't want to put anyone else's info out, so.
Okay.
Enough way. Okay, sorry, go on.
Then Miss Budnick, no, I'm asking questions.
So this is the 2K investigators.
The Miss Budnick, yes, she had asked questions about it, so I think the insinuation was it was a social media group of people.
Oh, okay. Well, let me hear the response.
The Miss Budnick, thank you. Do you know who the members of the 2K private investigators iPhone text message chat are?
Yes, ma'am.
Who are they?
Oh, okay, this I can say. My mom's sister, her fiance, and a family friend.
Anyone else?
No, ma'am.
Okay.
The court overruled the objection by Miss Budnick. When the hell did she object? Anyways, don't matter.
No, it says by Miss Budnick and then it goes down to the next line for the questioning.
Sorry, overruled the objection. Got you.
And then Miss Budnick, do you ever go a day without making content?
No.
Do you generate income from? Can you make content at this point without generating income?
No, I make content. I make money regardless.
Okay. Would you lose income if the restraining orders you are asking for are granted?
Yes.
Do you care?
No.
All right. Why? The Miss Fonseca, objection, relevance.
Overruled. There was much testimony yesterday on cross-examination that is sole motivation bringing the DVRO because of financial. That's overruled.
Thank goodness. But anyways, Miss Budnick, why don't you care if you lose income if these restraining orders were granted?
Because it's just money, and I would rather have peace over money. I'd rather have the threat stop. And there's other ways to monetize, and I was making money before this situation.
The Miss Budnick, okay, I have nothing further, Your Honor.
The judge, recross.
The Miss Fonseca, no, I'll pass.
The judge, okay, Mr. Gacy, I'll have you rejoin. So, are you going to call his mother again?
The Miss Budnick, just very, very briefly.
Want to go get her outside? I get to be Jen for a little while. Or is it Kim?
The Miss Budnick, yes, her name.
You can resume your seat at the council table. The petitioner, yes, ma'am. The bailiff, what's her name? That's Miss Budnick.
So Bree told her.
Yeah, that's what caught me for a minute. That's why I stopped, because it's Bree that says you can resume your seat at the council table. Who the hell does she think she is? But nonetheless, that's why I slipped up. And the petitioner says, yes, ma'am. I wonder if that was actually a typo. Because why would John respond to Bree, yes, ma'am? Like, what? Anyways, okay, so her name is Jennifer. Jennifer, the court. And just for the record, I think the court was a little circumscribed. What did I just say? Oh my god. Anyways, yesterday, I won't even try again. Oh my god. Now that we have another day, I think we have a little bit. She can testify. Are you going to ask her about what his reaction? You can also potentially ask her about her own personal reaction to seeing some of these things, because I do believe it is potentially relevant.
The Miss Budnick, thank you.
Okay, ma'am, if you wouldn't mind coming right behind here, stand behind the court reporter and raise your right hand. You stop right there, thank you, and raise your right hand, and my clerk is going to swear you in, the judicial assistant. And do you solemnly swear, or do you solemnly state that the testimony you may give in the state now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Jen says, yes. Judicial assistant, thank you. Please take the witness stand and please state and spell your name for the record. My first name is Jennifer, Jennifer. My last name is Kin, Kin. The judge, can you spell that, please? She says, K-I-N, as in Nancy. Canancy? We've read these too long. We're both going delirious. Oh my god. Jen is trying to say, Jen's trying to say N-K-I-N, N as in Nancy, and the judge put it together as Canancy. Maybe that's where they got Kim from, because her last name is Kim. Anyways, she's like, no, just Kin. Oh, Jennifer Kim. Kin. Jen says, uh-huh. Oh, okay, thank you. Jennifer Kin called as a witness on behalf of the petitioner and having been first duly sworn and examined, testify as follows. Direct examination.
Then Miss Budnick, okay, Jen, have you heard of a group chat called 2K Private Investigators?
Yes.
Then Miss Fonseca, objection, relevance.
Overruled.
What is it?
It is a group chat I created in my cell phone.
For who are the members of the group chat?
My daughter, my soon-to-be son-in-law, and a family friend.
Okay, and when did you create this group chat?
Like 2 years ago, I think.
Okay, what kinds of messages are sent in this group chat?
Anything. Mostly, most recently is Taylor Swift got engaged and sent it in the group chat. And my daughter commented back, yay, me and Taylor engaged at the same time.
Have you ever shared messages in the 2K Private Investigators chat about social media content related to John?
Yes.
In what capacity?
So if someone sees something, they'll send it in the group chat, or everybody is just not sending to everybody like, oh my God, like, I just want to let you know this is out there, so don't panic when you see it. Stuff like that.
Was there an initial reason why you created the group chat?
Okay, so about 2 years ago, I think we're about 2 years ago, John's account started getting hacked. His social media accounts just everywhere. So the people I trusted, my daughter, my son-in-law, and this family friend, everybody was just seeing random stuff. So instead of getting all these just crazy text messages and some duplicates of various things, I just created the chat. Just everybody send it here. But it wasn't just that. Like, there's prayers in the chat. It's in my cell phone. Like, it's not anything.
And does it have any social media platform?
No.
It's
The judge. What do you mean?
so, and then Miss Budnick. So I can rephrase my question. Is the chat limited to a cell phone text message chat?
Yeah, it's just in my cell phone. That's it. That's it.
Okay. And does anyone else participate in the chat other than the four of you?
No, it's just us.
Have you observed how the respondent's social media posts are affecting your son? Then Miss Fonseca, objection, vague as to time.
The judge. Yeah.
Then Miss Budnick, okay, I can rephrase. So were you there on March 25th of 2025? Then Miss Fonseca, objection, vague as to there. Then Miss Budnick, I can rephrase. Were you present at the respondent's Hollywood Hills home on March 25th, 2025?
We were present where the police had told us to meet him at and told us to wait there. Yes.
And where was that?
We were at down the hill, where everybody is calling and referring to as down the hill. And later, there was a point because more officers and there was limited space. Cars were coming. They had advised us to move further down the hill, down to a street in front of a neighborhood.
And did you, on this day specifically, March 25th, 2025, did you have an opportunity to observe John from this location down the hill from respondent's residence?
Yes.
What did you observe?
My son was in distress. He tried to. He was so upset. He was anxious. He started pacing. He tried to distract and go live for a little while. He got off live. He was crying. He started yelling, "Mom, I didn't oh my God. I didn't protect my son. I didn't protect my son." He started throwing up and dropped to his knees. The ladies, whoever's house we were at in front of, she came outside and she asked if we needed water, did we need her to call the ambulance? And I explained to her what was happening, what we were doing there, that we were told to wait there, and I told her that we were going to be fine. And at that time, we had gotten a call from the police officers to go back to the bottom of the hill. Pause really fast. I wish that they would have subpoenaed that lady to come in, because remember the judge is saying because she didn't see that on camera, that she's throwing that out. She says that John was not stressed because that piece was not on camera. So I wish that they would have had that lady come in. Yeah, that was hard to read. Yeah. Okay, sorry, go ahead.
That was just hard to hear.
Yeah.
And is this occasion on March 25th, 2025, the only time that you observed John in distress, specifically related to either actions of the respondent? Then Ms. Fonseca, objection vague as to time, leading relevance, depending on what we're asking about.
The judge, I think we have to sort of narrow it terms of post inquiry. So
Then Ms. Budnick, sure. Since January of 25, have you observed the respondent reacting from any content that he may... Since January of 2025, have you observed the respondent reacting from any content that he had seen?
respondent?
Then Ms. Budnick, I'm sorry, the petitioner, John, reacting to in response to any content that has been shared by the respondent.
Any content that, yeah.
What have you... Give me an example.
He gets tagged and stuff. And when he sees it, like, there's anxiety that takes over him. He'll experience a panic attack. January, actually, when we had security cameras put in our house.
How do you respond when John has these panic attacks?
I tried to calm,
The Ms. Fonseca, objection, relevance.
well,
The Ms. Fonseca, I don't think she's an expert or a doctor.
the judge. That wasn't the question. The question was, what did she respond? So, what is the relevance as to how she responded to his viewing,
The Ms. Budnick, I guess I can ask.
as opposed to her?
The Ms. Budnick, I can ask a question better.
Okay.
Okay. Do this year any content that you've seen about your son since January 2025, how has it affected you? Then Ms. Fonseca, objection, relevance, not a CHRO with mom.
The judge. Right. So okay. There is case law, which I don't know, there's case law that talks about one of the basis of a restraining order can be is if the potential protected person observes a child being exposed to an act that is considered DV under the DV Prevention Act. And the courts have held very recently that it can also be a basis to get a DVRO if a protected party has seen the restrained party commit DV or other acts towards their child. I don't know if there's case law that talks about the basis of the DV could be. I'm going to give it a little wiggle room as it relates to. Here's what I want to add. Not how she feels when she sees. There were specific acts that mentioned things regarding her.
Then Miss Budnick, okay.
The judge, I'll give you wiggle room in both of those. I'll let Miss Fonseca argue later that it's excuse me, relevant. No one has briefed this issue. I'd love to see what the parties think about how the case law applies. What I don't want to do is bring the witnesses back. So, subject to you arguing to me later that any of this is irrelevant, so I'll give some wiggle room to ask how she felt when she saw the attacks about him, and then how she felt when she saw the attacks about her, and let Miss Fonseca respond and kind of tell me whether it's relevant by case law.
Then Miss Budnick, okay. Then Miss Fonseca, okay. Then Miss Budnick, in light of that, I'm going to ask a different question. Have there been occasions in 2025 when you've seen the respondent make threats to your son?
Yes.
How many times this year have you seen the respondent make threats to your son approximately?
So many.
More than 5?
More than 5.
Then Ms. Fonseca, objection, leading.
Overruled. Go ahead. And then Jen says, more than 5, and because they're also combined with the threats against me.
Then Ms. Budnick, okay, and you said more than 5. There were more. Has this happened more than 10 times in 2025?
We're in August, yes.
Okay, so let's go to the threats against you. How do you feel when you see the respondent's threats about you? Then Ms. Fonseca, objection, relevance.
Overruled for now, subject to re-arguing it down the line. Go ahead, please. Jen says, it's upsetting. One, I'm like, we've never had a relationship where she needs to make threats to me. She's my grandson's mother. Like, she has been welcomed in my home. When she had W, I offered to she could come to my home because nobody came. No family flew to her, and she was by herself. So these things happen, and it's upsetting. It's like, why? I have not threatened her, you know? It's upsetting seeing my son upset, and I can't help him. I can't fix this.
How have you observed the threats you just talked about? How have you observed those affecting John? Then Ms. Fonseca, objection, lacks personal knowledge.
It's all based on her personal knowledge. That's the judge.
Then Ms. Budnick, correct.
The judge, go ahead, it's overruled. Jen says, sometimes he struggles to eat. He lost weight. Again, he will wake up in a panic or a random panic attack, and throughout the day, he has to focus and prep himself before he goes live. Like, get his mindset. He's taken time off live. He meant to take just a week off so he could just like focus on himself, and it ended up being 2 weeks, and realized he can't just stay off live. He's got to get back on it. Self-help books, coping books, having been coming into the house. Security cameras are at our house, at our new house.
Do you believe threats that you guys have received are credible?
Yes.
And then do you think these threatening posts would stop if restraining orders aren't issued? Then Ms. Fonseca, I would object based on vague and relevance. I don't know what threats we're even talking about this whole time.
So what threats are you talking about?
Then Ms. Budnick, sure. So Jen, have you seen a social media post from respondent where she says, fuck you and your fat ass mama. I'm going to fuck you all up. Then Miss Fonseca, objection, leading.
Judge, no. She just asked, wait, which? Just tell us the number.
Then Miss Budnick, exhibit 34.
Why don't you show the exhibit?
Then Miss Budnick, sure.
And we'll go from there. I don't know what else to do. That's 34, right?
Yeah.
Whereupon a
whereupon a
video.
video
Jinx 123 owe me Diet Coke. Whereupon a video recording was played.
Miss Budnick, Jen, have you seen that post before? I just played it today.
Yes.
How did it make you feel
Sick.
after seeing that?
To my stomach. Like, for what?
And did you observe how John reacted to that post?
Sick. Kept asking me if I was okay. Are you okay, Mom? And that wasn't the only threat during that.
The Miss Fonseca, objection, move to strike everything that.
There's no question. There's no question, Jen. Ma'am, I'm sorry. No, it's not your fault. You probably never testified. The way the rule is, she asks you a question, you answer it. You can't add additional if there's not a question. Go ahead.
The Miss Budnick, you've seen other social media posts where the respondent has threatened you or your son, correct?
Yes.
Okay, I'm going to play another one for you. I'm at exhibit 43.
Whereupon a video recording was played.
Then Miss Budnick, have you seen that social media post before?
Yeah.
In the reference to Applejack Cinnamon Stick, do you have an understanding of who the respondent is talking about?
John.
Okay, and how did.
Why do you believe that she's talking about John? Jen says, because she called him that when they were dating. Applejack cinnamon stick? Uh-huh. In your presence? The judge is probably mortified at this moment. And then Jen says, yes, I've heard it in my presence on FaceTime.
And Miss Budnick, and how did you feel when you saw that social media post?
Again, it's upsetting because my son is a good kid. None of this is true. Why are you threatening? Why are you terrorizing everybody? Like, for what?
And how was John? Did you observe how John was affected by that social media post?
He 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 comes to me and makes sure I'm okay. Are you okay, Mom? Are you okay, Mom? We're going to get through this.
Ooh. And that, going back to Exhibit 43, Brianna also talks about kidnapping our kids. Oh, I said that.
It's okay.
Did you observe if that threat had any effect on John?
Yes,
Was John affected by that threat?
he was. What is she going to do? Why is she going to take him? I got to protect my son. That's his mom. Why is she doing this? He was in a panic attack.
Okay, I'm going to play another clip for you. This is Exhibit 56. And let me ask you this. How many panic attacks has John had since January of 2025?
I don't even know. More than I'm going to say it's like the norm every other day. We have to focus on breathing.
And did he have panic attacks before the respondent started creating threatening content about him? The Miss Fonseca, objection, vague as to time.
Well, this is the judge. Well, I also said, didn't he have panic attacks before? You testified earlier. You stated seeing these videos around January of this year, correct? Jen says, correct. The judge, okay. So then you said, since January, he's had sort of panic attacks like every other day. Jen says, yes, ma'am. The judge, prior to January, how often would he have panic attacks? Jen says, not every other day. He would have panic attacks, but it wasn't nowhere near like where it is now. It's increased.
The Miss Budnick, and we were specifically talking about respondent social media posts since January. Have you been aware of any threatening social media posts by the respondent that predate January 2025? The Miss Fonseca, objection, relevance.
Judge, yeah, where are we going?
The Miss Budnick. Well, I think to the extent that the posts haven't the posts haven't started in January. They've been ongoing, but I was just trying to limit my questioning as to
So why are you asking about pre-January then?
the Miss Budnick. Well, my point was to try to the panic attacks are not that's that there's still a connection between I can move on. I see.
That's a little annotated.
Okay,
What are you showing?
this is exhibit 56.
Whereupon a video recording was played.
Have you seen that social media post before?
Yes,
And how did you feel when you saw that social media post?
it's upsetting to see it.
Then Ms. Fonseca, objection, relevance.
Overruled. This is Jen. It's upsetting to see it. It's upsetting to see it now because you don't know what she's saying. She's insane. She's coming across as insane to me. It's believable. I mean, is she going to hurt W? He's right there. Is she going to hurt W just to retaliate against John because she's upset with John? It's upsetting. You can't do anything, sorry.
Then Ms. Budnick, it's okay. In the three, just so we're clear, the three posts or social media recordings we just played, those are not the only 3 times that the respondent has threatened your family, correct? Then Ms. Fonseca, objection, leading.
The judge, that is leading.
Then Ms. Budnick, okay, I have nothing further.
Okay?
Thank you.
Cross examination?
Then Ms. Fonseca, yes. Then Ms. Fonseca, what does the term Applejack cinnamon stick mean?
She's referring to the character on the Applejack cereal box where he's the cinnamon stick as a man. Wait, what the? She's referring to the character on the Applejack cereal box where he's the cinnamon sticks are a man.
And how do you know that?
Because that's what she's referring to, and that's what she was showing John, saying that he resembles that. Oh, I gotta do a puzzle. Hold on. TikTok. I'm trying to read here. I don't have time for puzzles. Do that shit later, not mid sentence. Sorry. If I don't do it, it cuts me out. Okay. That he resembles that. I'm gonna have to look it up because I don't know what it is, but I'll look it up. That was one of her very first names that she had started calling him.
So you're saying that she explained that in front of you?
I asked I asked John what she was referring to because he was upset.
So you didn't actually observe a FaceTime call between the two of them where that was initially used?
Oh, I did. I did. I overheard the FaceTime call. Then I went into the bathroom. He was right there. And he was getting ready to leave. She was on a FaceTime call on the phone.
Okay, so the explanation came from you overhearing it on a FaceTime or from John at a later date?
Both.
Okay, is your TikTok screen name Kindashian?
Correct?
Have you ever said anything disparaging about Brianna online? Then Miss Budnick, objection, relevance.
The judge, look.
Then Miss Fonseca, open the door.
The judge, you did open the door, and she indicated how. Look, one of the main issues here is the credibility of the concern that Miss, harassed, caused, disturbed peace, and all of that. So there's a lot of testimony on how these made her feel. And so this is potentially impeachment. So, whatever. I guess it depends on when it was said. Do you have something? What are you directing?
Then Miss Fonseca to her TikTok post.
What date and?
Then Miss Budnick, and what exhibit? Then Miss Fonseca, this is Exhibit L, Bates page 236, and I would frame this as last year before the DVRO trial.
So this is relevant how?
Then Miss Fonseca, because of what you just said, that this, I guess, alleged secondary victim that is testifying that she's so bothered by what my client is saying online was making disgusting comments about my client when she was oh my goodness, when she was pregnant with W.
Okay, hold on.
Then Miss Budnick, I would just
Yeah. Oh no, I did it again. What page are we on? Sorry, I clicked out.
42 of 69 on the little thing, and then it's page
Perfect.
38.
All right, I'm there. 42.
And then I'm on line 22.
Okay, got it. Thank you.
And then you're welcome. Then Miss Budnick, sorry, if we're getting into content that, like, I limit my questioning to January because there is a history of correspondence and posts and things that we could have testified about that we didn't. Then Miss Fonseca, but we're talking about, again, this is not a CHRO proceeding, but we allowed 20 minutes about her feelings, about things being said about her online, even though she's not a protected party and there's nothing pending against her.
Hold on. Slow down. I tried really hard to make a distinction between the potentially defamatory comments, which I've now said you guys know how I feel about that. First, there's threatening comments, which is clear and can very well be covered by the DVRO. And it's the kind of commentary that is not covered even by, that's criminal law. Is that criminalized comments, words that are potentially threatening? So she didn't talk really. Much of her testimony was not about alleged declaration. Much of her testimony was specific to Miss Budnick, was very direct. And I think showing her clips that may have made some defamatory comments also contained threats.
The Miss Budnick, correct.
The judge. And so that's what I mean, or that's what I think the focus should be on.
The Miss Fonseca, well, one of these is threatening.
Okay, so focus on that.
The Miss Fonseca, okay, so then that one is the next page, 237. Do you?
And what's the date of that?
The Miss Fonseca, it was sometime last fall. I don't know the date. It was right before the restraining order, in which this same witness testified on behalf of her son. The Miss Budnick, I'm reading the exhibit. I object to the relevance of this. I don't see the connection that the Miss Fonseca, again, a threat. So specifically, she is commenting to another chat person about taking my client to court for grandparents' rights if the baby has her DNA.
Okay, hold on. I'm going to let it in to avoid the further. It has, to me, somewhat minimal relevancy based on the confines of.
The Miss Budnick, let's go ahead. The Miss Fonseca, is this your username Kardashian posting on TikTok?
Correct.
The Miss Budnick, let me put it on this.
The judge. And this is Exhibit M, right?
The Miss Fonseca, she has the packet up there.
The judge. You have that up there, ma'am? You have the giant packet? John. Yes, ma'am, I see it. The judge. Okay. And you can also see it up there.
The Miss Fonseca, and this is you saying, quote, the other funny part is that if it's my son's DNA, I'm involved now, and I will take her to court I will take her to court too for grandparents' rights. She she better ask someone, end quote.
Correct.
Sorry, I thought I was reading yours all of a sudden, so I was like,
Nope, you're good. I love how she said, "Yep, I said it," and should.
And what did you mean by that?
At this point, she had made it very clear that she, at this point of the relationship, she made it very clear that she did not, her feelings for me and the text messages I had received from her in my phone prior to, I was going to be involved with this baby if it was my son's. We were also during this time made aware that she had been, can I say that, escorting, which is fine. So that's why I specifically said DNA.
And when you say this time, what like approximate date period are you referring to?
This particular thing, I don't get on here and like try to go back and forth and do anything. I'm not about this chaos and stress.
Then Ms. Fonseca, I would move to strike everything as non-responsive.
The judge. So, ma'am, I think the question is, when you say this time, was was there something that happened right before that said this that caused you to say this time I'm going to get grandparents' rights?
Then Ms. Budnick, no, she doesn't say that. I think the question is, what date?
The judge. Oh,
Then Ms. Budnick, were these?
the judge. Okay. What do you, or she says, okay, what? Do you know what general time frame this was from? This posting? Was it last year? Was it this year? Jen says, it was around the time that she, very close to the time that she announced that she was pregnant. And then the judge, okay, so a couple of years ago. Jen, when she was pregnant, correct. The judge, okay, because W is a year and a half. Jen, 16 months today. The judge, so probably 2 years ago. Jen, uh-huh.
Then Ms. Fonseca, and at the first restraining order trial for the first restraining order that your son filed, you testified.
The judge, okay, hold on. Did that trial go all the way through or was it settled mid?
Then Ms. Budnick, so what had happened is my client completed his testimony cross redirect.
All right.
My client's witnesses had all testified. We were at the point where we were going to call the respondent, and then we were communicating a settlement offer, and we agreed to just.
So his mother testified and was subjective to cross examination.
The Miss Budnick, exactly.
Judge, okay, I'll give you a little wiggle room. I think I made it really clear on my thoughts about the prior restraining order, but I'll see where you're going.
The Miss Fonseca, you'll see.
Okay. Okay.
Yeah, you'll see. The Miss Fonseca, so you testified at that trial, right?
Yeah.
And did you testify about wanting to have or that you had an expectation of privacy?
I do, yes.
Do you still believe that currently?
I would.
The Miss Budnick, yeah, this is not relevant. Objection.
What? What? Okay.
The Miss Fonseca, you'll see where I'm going with this.
Well, I don't know if I will. So, everybody has some reasonable expectation of privacy and some that use. I don't know what that means. I mean, people have a reasonable expectation of privacy theoretically that are in their bedrooms, and in their doctor's offices theoretically, but everybody's involved in the internet and social media. So these individuals may have less of a reasonable expectation. So I'm not really sure what that question means.
And Ms. Fonseca, this is going towards what John testified to the last 2 days about mom being so bothered by the harassment that she's experiencing on behalf of my client that she has to turn off her phone. Her workplace was affected. It's personally affecting her. So there's something right in line with Dad's testimony that I'm going to be asking her.
Okay, we're so far beyond, and I did give Miss Budnick a little wiggle room with 352. I mean, I guess, because I let her get into the threats against on how they made her feel. But she just testified that these posts that you were upset about happened after the first of the year, which is prior to the date of the initial restraining order. My understanding with all of these parties is that there have been ebbs and flows in how they engage with each other, even including Santos, both on social media and other ways. So, again, I'm not, if you have testimony that is relevant to the testimony she gave regarding these social media posts, because my sense is I wasn't involved in the first one. Did the first one trial where there are similar types of social media posts?
And Miss Budnick, it involved other types of AB, but there were, in addition to the other types of AB that were at issue, there were also social media threats and posts. Then Miss Fonseca, was it a video trial like this? Was it a video trial like this? No. Then Miss Budnick, I'm so confused by that. Then Miss Fonseca, if that's what you're asking, if it was a lot of this sort of evidence that was presented, no. Then Miss Budnick, and I mean, just to give some background, it was because a lot of the AB was at issue. There was physical violence, having
Okay, okay.
the Miss Budnick, yeah, it wasn't necessarily focused on TikTok posts.
The judge. Yeah. So, yeah. I'm not really sure how relevant your question is to what she's testified today. It sounds like it's different types of evidence.
The Miss Fonseca, credibility as to her privacy concern and how all of this harassment online affects her and her family, specifically John. So I will move forward in the foundation I was trying to lay and ask the most pertinent questions.
Okay, I'll give you a little wiggle room.
The Miss Fonseca, you're aware that John filed an emergency motion on March 24th, 2025 regarding a visitation incident. The Miss Budnick, object. The Miss Fonseca, correct.
Jen, correct?
The Miss Fonseca, do you regularly speak with T pages on TikTok about this case?
I speak with anyone can be I speak with anybody can be considered a T page. The judge, wait, hold on. I'm so old. What's a T page? Jen, a T page, and you can label anything a T page. It's like a gossip page, or they just post. That's how I take it. It's like a gossip page. They just post stuff. The judge. So do you or some so do you or someone can submit things to a T page, or they post it on the T page? Jen says they can post whatever they want. T pages post court docs. T pages post pictures. T pages post clips of their lives. The judge. So those are pages on like TikTok? Jen, correct. The judge. That are considered T pages? Those are like gossip pages? Jen, correct. Judge. Do you maintain a T page? Jen, I do not. The judge. Okay, sorry, now I understand.
Then Miss Fonseca, on that day in question, when your son filed that motion, did you engage in private conversation on TikTok about the court documents before they were even filed? Then Miss Budnick, objection, relevance to this?
Okay, what's a private conversation?
Then Miss Fonseca, like a direct message, an inbox message.
Oh, that goes to credibility. She can answer that. Jen said, I did.
Then Miss Fonseca, did you give two particular T pages that day the heads up that Miss Budnick was filing a motion before it was filed?
No, there was one on the 24th and then another one if it was a T page, I don't know if it was labeled a T page, but it was someone that I was venting to. I don't know if it was a T page or not. That just caught me at the right time. During that time, my grandson had been taken. He wasn't where.
And Miss Fonseca, I move to strike everything as.
It's non responsive.
And Miss Fonseca, yeah. So, as to that secondary conversation that you mentioned having that week, was it about the yet to be filed restraining order that we're here for today, that you were giving the T page the heads up about?
It possibly could have been.
Do you recall saying John's attorney is filing something else this week? I will tell you when that's been filed so you can pull it first. Nobody will know until Bree opens her mouth about it because she will get served again, end quote. Do you recall saying that?
Correct.
So since your son has been engrossed in this litigation, did you regularly give T Pages the heads up that new filings were incoming from Miss Budnick before they were filed?
No, I would not.
So that particular week of the big March incident, did you do it multiple times?
That clearly that message, and then there was another T page that was called, I won't say the name, but called blah 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 blah.
And why that particular week did you give these T Pages the heads up about these filings?
Because the one was on the 24th, and to me, Bree was again like that clip we just saw where she was lying in bed with W. I knew Bree. Doesn't respond to John in The Family Wizard. I knew that this T page, because it was notorious, excuse me, notorious for, because it was notorious and known for posting the court docs. If they posted that court doc, the internet would get it and then would call out to Bree and would bring it to Bree's attention. That was my thinking. Really fast. I didn't say the T Page's name because I don't know if they want that out there. That's the only reason why. But these court docs are out so people can see them. I don't want anyone to think it's me, but I just don't like to put other people out if they don't want it. You know what I'm saying? It's a great page though. I love them. Okay.
Ooh. So you were providing court documents in advance online to try to get Bree's
I didn't.
attention?
Hold on. Oh god. Provide any documents. Then the judge. Whoa, whoa, whoa. Jen, sorry. The judge. No, it's okay. Let her finish. So you were, and be careful with the argument. And okay, there's good cross examination, but a fine line between that and.
Then Miss Budnick, okay, I would object. Then Miss Fonseca, I'll rephrase. Then Miss Budnick, okay, go ahead. Then Miss Fonseca, so instead of that question, to get Brianna's attention that week, did you call her?
John communicated with her and tried to communicate with her.
Oh, you skipped one.
Oh, I did?
Yeah, it was,
no,
no,
I'm sorry.
I don't communicate with her.
No, I don't communicate with her. Sorry.
Did you text her?
John communicated with her and tried to communicate with her.
Move to strike everything as non-responsive.
I think she said I don't communicate with her. I think that answers your question.
Then Miss Fonseca. Okay, did you ask John to call or text her?
I asked John if she responds and to message that you put out there. Has she reached out to you?
And what did John say?
No,
Did John tell you how many times he reached out to her?
I didn't ask.
So, okay, and you testified earlier that you were there at the bottom of the hill during this. We're calling it visitation incident on March the 25th, right?
Yes.
And did you know that you were being filmed?
No.
So did John and you have anybody else there with you?
Correct.
Who was where there with you?
His social media manager, 4 other officers, and one of his other friends.
Who was the other friend you're referencing?
I don't know his real name. I just know him as I just know his name is Swag. I call him Swag.
Is that Swagboy Q on TikTok?
Correct.
Oh man, she finally got his name right.
I know, not Swaggy.
Anyways, were you sitting in a rented SUV at the bottom of the hill during this interaction?
Correct.
After you guys got W back, did you return with John and W to Swagboy Q's, I guess, residence?
Correct.
Where you'd been interviewed by him on a video at that residence? Then Miss Budnick, objection, vague as to interviewed. Then Miss Fonseca, we saw the clip yesterday. I would gladly replay it.
Yeah, well,
Then Miss Budnick, and also objection as to relevance.
oh, it's relevant. I won't look. She's impeaching his testimony that this was so traumatic for him, okay? Go ahead. Do you recall that? Swag Boy Q asked you some questions online on Like Alive. Jen says, I don't remember. So much happened that day, but I'm sure he did. I'm sure because also later that evening, I had gone live.
Then Miss Fonseca, and do you recall, again, back to being at the bottom of the hill, do you recall John engaging with Swagboy Q's camera while you said that he was distressed and throwing up?
That was happening when we were in the neighborhood, not at the bottom of the hill.
So are you changing your earlier testimony that he was throwing up, I guess? Then Miss Budnick, objection.
Okay, counsel, let's watch the argumentative, please. She's not changing her testimony.
Then Miss Fonseca, okay, when was he throwing up that day?
When we were down in that neighborhood.
So down at the bottom of the hill, or are they different?
No, there was 2 different locations. The police officers first had us meet them at the bottom of the hill. They were calling in more officers and told us to go further down the hill. The judge, do you need her to slow down? Can you slow down, please, ma'am? Jen, sorry. The judge, go ahead.
Miss Fonseca, so are you saying that in the place where Swagboy Q was filming your son, that is not where he was also distressed and ill?
I recall my son.
Then Miss Budnick, objection, this is very vague as to the place. I think if there's a clip, maybe she can show it.
The judge, are you basically in a, I think your position is he was, wait, I lost my spot. Sorry. Oh, here we go. Okay, I think your position is he was not credible about crying. Is that what you're saying?
And Miss Fonseca, well, both of them. Honestly, yes.
Okay, go ahead if she can answer it.
Then Miss Fonseca, can you read back that question?
Just re-ask it. And then they did a read back anyways. Jen says he was distressed the entire time.
Okay, I will play this clip.
The judge, which one?
It's the one we played yesterday, but I'll just play it a second time. Then Miss Budnick, well, she wasn't here yesterday. Then Miss Fonseca, that's what I'm saying. That's why I'm replaying it.
What number?
Then Miss Fonseca, okay, Exhibit KK. I don't think this is one with the transcript because it was just music. Then Miss Budnick, so then again.
Thank you. Okay, again what?
Then Miss Budnick, the question was about being interviewed, and apparently this is the transcript of just music. There is no language. Then Miss Fonseca, it's not a question about being interviewed, it's...
Okay, just play it, ladies. I've said about speaking objections multiple times. It means relevance, foundation, hearsay, asked and answered. That's a valid objection. What is the objection?
Then Miss Fonseca, I guess there's a lack of foundation.
Lack of foundation. Okay, so are you asking her to, well, there may or may not be. She first asked her whether she recognized it and...
Then Miss Fonseca, and it's again the credibility.
Okay, you can potentially, I'm giving you the opportunity to do it. Lay the foundation, whereupon a video recording was played.
I like how Miss Fonseca was arguing Miss Budnick's objection.
I know.
For Miss Budnick. Anyways, then Miss Fonseca, is that a representation of John being distressed at the end when he was?
That's not the question. Do you recognize the video, ma'am? Jen says, I do. The judge, and what does that video represent, Jen? When we first got there and we were waiting for the police to arrive, the judge. And does that accurately depict how your cars were set up? Thank you. Where they were parked and all of that and that. Date and time, Jen. When we first got there, and yes, the judge. Okay. Now you can ask your remaining questions. Why does the judge always have to lay the foundation for her? It's just like she can't, Miss F can't do it herself. Sorry.
I literally was just thinking when Bria's always online saying like, my attorney is so great. My attorney eats. My attorney is a dog in the courtroom.
No,
and
her attorney is eating up her money. That's what she's doing.
Yeah.
She's eating up her money, and that's it. Like, it's craziness reading this. Okay.
Then
Almost done, guys.
So is that where you're testifying that John was throwing up and distressed?
No.
So when was that part then?
When we had to go further down the hill, and we weren't up in there. We had to go further down, and we were in this, I don't know where we were. We were down the hill, further down that spot in a neighborhood, like in a street. To me, what looked like a street. There was houses on both sides. It was a level street.
How many minutes between the footage that we saw there and when was oh my goodness, I'm really struggling. How many minutes between the footage that we saw there and when was it that between that moment and when you moved to the bottom of the hill?
I have no idea.
So
I don't know. I wasn't taking time. I was upset. We were upset. I didn't even realize. I don't know how long we were there the entire afternoon. This is the judge. Okay, let me cut to the chase. Your position is, in that video, he doesn't look to be either stressed or upset, correct?
Miss Fonseca, and the credibility as to when this throwing up and anxiety was happening.
The judge. I got it. Short of us having a picture of this stuff or not, you were going to ask me to make credibility determination as to whether that's true. You're going to ask me to look at that video and say that that does not look like someone who is distressed. I'm trying to be cognizant of the time. Your client still has not testified. Let's move on.
Then Miss Fonseca, does John refer to you as a clipper?
What?
Then Miss Budnick, objection, relevance. Then Miss Fonseca, does John refer? Then Miss Budnick, vague. Then Miss Fonseca, open the door with the entirety of the 2K private investigator's testimony earlier. And this is also impeachment as to John's testimony. Then Miss Budnick lacks personal knowledge. Then Miss Fonseca, she give 20 minutes of testimony about this.
It's not a tit for tat, ladies, and you guys are missing the big picture here. But it's for you to present your case however you want to do it. Do you know what a clipper is, Jen? I know what a T-page is. I don't know what they're referring to as a clipper. No. The court or the judge. Okay, move on.
Then Miss Fonseca, do you and the other 3 family members in that iPhone chat message that you testified earlier, do you guys regularly find content about my client and send it to your son?
No.
So what is the point of that group chat? We already went over this.
I know.
Sorry.
Because it's in my phone. It's my personal conversation with my family.
Is there a reason why it's called 2K Private Investigators?
Because it's funny.
So that has nothing to do with what you actually use the group message for?
I can use it for whatever I want. It's my phone. Preach, Jen.
Good for her.
Yeah.
And it's on your phone right now?
Yes, it is.
And is it your testimony that it's only you and the 3 immediate family members that are in that group chat?
Correct.
Would you be willing to show that?
The judge. No, we are not going to do that. No. Nope. 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 Mm-mm.
Then
Nope.
Miss Fonseca, I wouldn't say open the door.
The judge. No. You are not asking this witness to show her private phone on an ancillary is it supposed to be terror? I don't know. Territory?
Yeah, I don't know.
That's a crazy word. Tangible issue. I'm not allowing you to do that.
Then Miss Fonseca, okay, I rest the rest of the stuff that I was going to ask her was about custody visitation.
Okay.
Oh, wait.
Sure.
One thing, though, about the, logistics of your home setup. So your son, let's say in the last 12 months, your son rented his own apartment for a while, correct?
Correct.
And when did he rent his own apartment?
It was only a 6-month lease, and he just moved out all the stuff out of it in May.
May of 2025?
I think so, yeah.
And when he had the leased apartment, how often was he over there?
Wait, was it May? Whether he had whenever he had a big series and big battles, because when those go, he usually gets louder than normal. So he's loud in the house. And when we first agreed to go rent this, it was going to be like a workplace. It was not out of the house. It was out of the house because he initially. Oh, sorry. Let me rephrase. It was out of the house because we are initially in the small 2-bedroom.
So, how many times a week, when he had the apartment, was he in the apartment?
At best, 4, maybe.
And would that be all day or like a few hours each time?
A few hours each time just to go battle and, like I said, run, like do his series. The judge. Is this going to custody and visitation?
No, it's both really. That and the testimony about all the observations she allegedly made since January about his well being or lack thereof.
The judge. So your point is she didn't have a lot of opportunity to make those observations.
Right. So the point, okay.
Okay.
Then that's it.
Okay, anything else?
For me?
Yes.
Oh, no, I'm done.
Redirect?
Then Miss Budnick, just, I guess, a couple of things.
Redirect examination?
Then Miss Budnick, the messages you were asked about that were communicated via social media in March of 2025, were those were private messages, correct?
Correct. They weren't comments posted for everybody to see.
Okay, and they weren't publicly shared on social media.
No.
Okay, the clip you were shown of John pacing on the street. Was he in distress while you were at that specific location? Then Miss Fonseca, objection, lacks personal knowledge. Then Miss Budnick, did you observe him in distress while you were at that specific location? Then Miss Fonseca, objection, asked and answered.
Overruled.
Then Miss Budnick, I can re-ask my question.
Let me ask it.
Thank you.
That video, Jen, they've only shown you one video. You've indicated in response to Ms. Fonseca's questions that's not where he threw up. He threw up somewhere else. Jen, correct. The judge. In that video, during the time that was depicted in that video, did you observe him to be in distress during that time period? Jen says correct. The anxiety had started when we were actually on the way there. That's when he was pacing. The judge, okay.
Then Miss Budnick, that you had testified that John was in that filming apartment for a couple of hours, about 4 days a week. The rest, the Miss Fonseca, objection, misstates her testimony.
Ask your questions.
Then Miss Budnick, sure. When John wasn't in the apartment filming content, where was he living? Then Miss Fonseca, objection, oh. Then Miss Budnick, you know what? It's not relevant. I have nothing further.
Okay, all right. Anything else based on those last couple of questions?
Then Miss Fonseca, no, Your Honor.
Thank you so much for coming.
Then Miss Budnick, is she okay to wait in the courtroom now that she's done?
Well, no, because there may be some redirect, no?
Then Miss Budnick, okay.
So once they're a witness, she needs to wait outside.
Then Miss Budnick, understood.
Please do not film in the courthouse. You can film outside, okay? Any other witnesses?
Then Miss Budnick, are we going to take a break at 3 for a bathroom break?
I was going to take a break now if you're done with witnesses.
Then Miss Budnick, yes. Then Miss Fonseca, she's not calling Brianna? Then Miss Budnick, well, no. I have Brianna, but I thought we talked yesterday about Miss Fonseca questioning Brianna, and then my cross would be open to.
I want to give you ample opportunity to present. So let's do that first. And then we'll be open-ended about, are you starting with your client?
Then Miss Fonseca,
Okay.
Then Miss Fonseca, because I thought I basically already did John, right?
Yeah, that's fine. Yeah.
Then Miss Budnick, that's my understanding.
3:00 to 3:05.
Then Miss Budnick, and then, just so I'm clear, I can leave my computer as long as it's closed.
Yeah. Right, Michael? Judge, judicial assistant. Yes. The judge. Okay.
And Miss Budnick, okay, thank you so much.
And again, no filming outside of the courtroom. No filming in the hallway. If you're going to film outside of the courthouse. Thank you. A brief recess was taken. The judge. All right, we're back on the record. So, Ms. Fonseca, are you ready?
The Miss Fonseca? Uh-huh.
Who are you going to call?
Brianna.
Okay. Will you take the stand?
Ready?
You may begin, yes. Brianna Lynn Olson called as a witness on behalf of the respondent and have been first duly sworn and was examined and testified as followed. Direct examination.
The Miss Fonseca. Brianna, how long have you been a TikToker?
Since about 2019.
And this is your primary source of income?
Yes, it is.
And is the person that you are in real life the same person that you are on the internet?
Not necessarily, no.
And what about the difference between your real life persona and your online persona?
I would say my real life persona is pretty chill. Okay. And then my online persona is extremely exaggerated.
What is rage bait?
Rage baiting for me would be saying things or doing things online that are controversial that you know will get a reaction.
And getting reactions, does that mean that you get more followers?
Incoming followers, views, money.
What about like gigs?
Absolutely.
Do other TikTokers, specifically John, do they rage bait?
In my personal opinion, yeah.
And when you're rage baiting, are you necessarily telling the truth?
No.
Okay, do you recall John's testimony on the first day of trial regarding somebody that he called GTA?
Yes.
Do you know what GTA's real name is?
No.
Do you know him on a personal level?
No.
How
Objection,
many?
perjury. Sorry. Add that in. I did. If you guys weren't here yesterday, I played a video yesterday of about 10 different times that her and GTA were together, which is why I say that. But okay, we'll continue. Let's get through this.
How many times have you met this person in real life?
She's such a liar. Oh, sorry. One time.
And did you meet him privately?
No, it was in a public setting.
Was there other people around?
Yes.
Did you have any one-on-one conversations with him in that setting?
Never.
Online, who is this person, if you know?
Okay, so now we have to go to the second one, right?
Yeah.
Because mine ends there. Okay, I gotta pull up the second one. Hold on really fast. Part 2. Okay. Give me 1 second. I'm going to get into that, but hold on. Today, Junior.
Objection.
Is this one? No, here we go. Hold on. Remember, she said, she saw him one time?
Yeah. Hold on, I'll go.
Oh, today's turn off. There's one.
Thanks, Ash.
This is a different time. 2.
Thank you, back there.
3. It's a different time. 4. A different time.
Where'd you get your jacket? I spent $1,000 on this jacket.
Your girl doesn't even come on the screen with you. Be for real. Why is it taking so long?
6.
It's a drive-by. Not car locking. DJ not car locking.
I told you, bro. Bree just trying to cover up the DV charges. Oh my god.
Anyways, I think I proved my point. That was like 7 or 8 times. So she completely lied under oath again. But nonetheless, let me go back to what I was supposed to be doing. I just like to prove my point. Okay.
So the question was, online, do you know his persona or something like that?
Okay. I don't know much about his online presence. I've never followed him or gone live with him. Oh my god, I can't believe it. Or gone live with him.
Is he a TikToker like you and John?
Yes, he is a TikToker and live streamer.
Have you ever, like we saw those battle videos on some of the exhibits, have you ever done a battle video with this person?
Not that I recall.
So have you ever directed this person to talk about you on his platform?
No.
Have you ever directed this person to talk about John on his platform?
No.
Have you ever directed this person to make threats towards John on his platform?
No.
Have you ever offered GTA any compensation to make comments about John on social media?
No.
Do you recall John's testimony, I think it was yesterday, regarding a water pew comment on the day that the police were at your house in March of 2025?
Yes.
And do you recall streaming something about a water pew during the day that the police were there?
Yes.
And specifically, did you threaten to do something to John with a water pew?
No.
And from the best of your recollection, what was the conversation on stream about a water pew?
On my streams, I keep things very lighthearted and funny. She's lightheaded, that's why I said that. So I believe I said something in a joking manner about spraying somebody outside of my house with a water pew.
And when you're talking on the streams, are you talking to yourself?
No, I'm talking to either people in the room or to the chat.
So people in the room, meaning real life people in the room?
Yes.
And in the chat, meaning like the people that are in the live chatting to you?
Either live chatting or TTS, which reads comments out loud.
So the TTS reading comments out loud, do people have to pay money to have their comments read out loud?
Yes.
When you're engaging with the audio comments or the written comments, are you reading comments out loud on your lives?
Yes.
Do you pick and choose based on any particular, metric on what you read, or is it just random?
It's absolutely random.
So when on these clipped streams of you, strike that. Let me back up. Do you have any control over what third-party clips of... Hold on. Do you have any control over what third parties clip of your kick streams?
Absolutely not.
No, but you do have control of what comes out of your mouth. Okay.
Right.
Do you have any control over what clippers repost of your kick streams?
No.
Do you have any control over what comes up on other users' FYP page on TikTok?
No.
So speaking to your boyfriend, Santos is the name of your current boyfriend, correct?
Yes.
And prior to your relationship with Santos, are you aware if him and John had some sort of relationship?
Yes, they did.
And how do you know that?
He testified to that, and I also saw it myself.
Saw it on the internet?
Yes, on the internet.
And what did you see specifically?
Like a lot of banter, like back and forth.
So prior to your relationship with Santos, do you have any personal knowledge of John and Santos having some sort of falling out?
Yes.
And when would you say that happened?
Around the time of the March incident and directly after when we started dating.
Do you know specifically why John stopped, being nice to Santos?
I'm not sure why.
Have you ever directed Santos to go on his Chap Snap and post about John?
No.
Have you ever directed Santos to make threats to John on the internet?
No.
Have you ever accompanied Santos to, I guess, publicly approach John?
No.
So specifically to, do you recall earlier John testifying, I think today and yesterday, about something that occurred in June of 2025 at a hotel?
Yeah, I recall.
And do you recall seeing the video clip that John played today of Santos and another man at that hotel?
Yes.
Did you see yourself in the video clip?
No.
Did you hear yourself in the video clip?
No.
Were you personally there with those two men at the hotel?
I was not.
So do you recall seeing then the video of you that I think was played today of you in the blonde wig talking about Santos and the other man at the hotel? Do you recall watching that clip?
Yes.
And do you recall saying, "We did this, we did that" in that clip?
Hold on. My thing keeps going out. Sorry, guys. What page are we on?
Sorry, I was clearing my throat. It is page 69 on like the page itself.
Okay, that's exactly where I'm at. Okay. What line number? Wait, because
Oh
you
no,
just
I
asked, so
lost my
did
spot.
a lot of banter back and forth.
21.
21. Okay, down further. Here we go. Okay, so the answer is no.
Oh,
Right, because
wait,
you asked,
no.
have you ever accompanied Santos? Here, we'll start here with a question. Have you ever directed Santos to make threats to John on the internet? She answers no, and then you pick up there.
Oh, we're down further.
Oh,
Our pages must be different.
okay. What was the question you just asked?
It was in that clip. Oh no. And what did you mean when you said "we" in that particular clip?
No.
I don't know.
Okay. Wait, no. Yeah, and okay, I got it. And do you recall saying "we"? And then what do you mean? Okay, got it. Here I am. Because her question is, and what do you mean when you said "we" in that particular clip? Okay. In that clip, I was not referring to the incident that we saw today on video. I was referring to something that happened a day before.
So it was not something at the hotel?
That's not what I was referencing to in the video.
Okay. Now I'm going to ask you some questions about some of the exhibits that John presented specifically, okay? So do you recall, I think it was John's Exhibit 26, it was a stream where you made comments about his mom saying something about her being fat and needing a BBL. Do you recall watching that clip?
Yes.
Was that during your parenting time with W?
No.
Was W anywhere in your presence when you had this conversation on Kick?
No.
Were you reading comments from the live stream during that Kick stream?
Yes, I was.
Were any of the comments talking about John's mom?
Yes.
And so do you know if you, I guess, strike that. Did you personally make those comments about his mom? Then Miss Budnick. Objection, vague as to those comments.
Well, she already said she made the lump sum of those comments. Which ones are you referring to?
Then Miss Fonseca, I guess we can do each. So the comment about the BBL, did you personally say that?
I did say that.
Were you repeating anything that you saw on the screen that said BBL?
Yes, I was. The judge. You're starting to get a little leading. She's not objecting, but...
Then Miss Fonseca, what about the comment about his mom being fat? Did any of the chatters, or I guess, is that chat? Any of the people in the chat say that first in the stream? Then Miss Budnick, objection, leading.
That is leading.
Miss Fonseca, did anybody in the chat during that stream say anything negative about John's mom?
Yes, they did.
And did you repeat any of those comments that you were reading that were coming in on that chat on that stream?
Yeah.
Okay. Do you recall? I think it was John's Exhibit 34. We've watched it 2 different days. Do you recall the clip of you on what looks like a boat in the nighttime?
Yes.
And was W there on the boat?
No.
Was this during your parenting time with W?
No.
And do you recall ever saying John's name during that clip that we watched?
I did not.
And did you specifically say Jen's name, his mom?
No, I did not.
Okay. And was there any live, chat during that stream that night?
Yes, there was.
Okay. And do you recall the clip? I think we watched it yesterday of you and Santos at the restaurant, and you were wearing the blonde wig. Do you recall watching that exhibit of John's?
Yes.
And during that clip that we saw, did you ever direct Santos to say anything about John? Then Miss Budnick, objection, it's just vague as to what clip we're talking about.
What number?
Then Miss Fonseca, I don't remember. It was the only one with the 2 of them and the blonde wig. So let me see. Oh, I think it's 73. No, that's a different blonde wig.
Oh my God.
I guess I can
Yeah.
strike that if council doesn't remember. It was her exhibit that was the Miss Budnick. Well, let me, I can assist. Let me just figure out which video we're talking about. Maybe 25? I think it might have been exhibit 25. The Miss Fonseca? Yes. The Miss Budnick? I believe it's 75, actually. The Miss Fonseca? 75?
The judge, I have 73.
The Miss Fonseca? I think it's 70. Oh my God. The Miss Budnick? 75 is the 2 of them.
The judge, did you show me 75? I don't think that's one.
The Miss Fonseca? Yeah, no. That one isn't marked. It was the other one that I said.
Oh, I do have 75. Hold on. Santos? Yeah, I think it's 75.
The Miss Fonseca? The 25 is the one that John specifically testified about with Bria and Santos at the restaurant. The Miss Budnick? 25 wasn't one of the ones that I showed.
Yeah, I don't see 25 in my stack. Transcripts?
The Miss Fonseca? Well, I mean, I can skip it.
Or you can show us 25.
The Miss Fonseca? It was theirs. I don't know which one it was. It was one that they showed and then asked about on the second day. I mean, I can skip it. Then back to questioning. Okay, so do you recall the video that now John and his mom testified about where it's dark? You're on a couch and you're saying something about burning something down. Then Miss Budnick, can we, objection, vague as to what clip we're talking about?
Just show her the clip.
Then Miss Fonseca, it's your evidence. Then Miss Budnick, I sent them electronically.
Counsel.
Then Miss Fonseca, I'm just trying.
Stop.
Then Miss Fonseca, to accelerate it.
Stop. Okay, when you ask somebody about a video, there's a lot of video. It's then coming upon you to then be ready to show them the video. To say, well, it's your evidence. You're asking her the questions. So you want to ask her about a video, then have that video teed up.
Then Miss Fonseca, well, then I guess I could just reserve for cross, because if she's going to ask about the same videos, because I can't quickly find her exhibits.
I listen, I know there's attorneys in the chat, especially AA. Listen, you have all of my respect. I would fucking snap at this point. This is horrible. That's all respect to all of the attorneys in the chat. Jesus. Anyways, the judge said
AA just said, that's so insane. That's so crazy. This is wild.
yeah, literally losing brain cells. I can't deal. So you have all of our respect. Okay. The judge says, all right, are you going to show her the all the videos?
Then Miss Budnick, I can assist and pull up the video.
Well, that would be great.
Then Miss Budnick, I have no problem doing that.
That would be great.
Then Miss Budnick, I just wanted to know what video we are talking about.
That would be great. That's more helpful than saying it's just your evidence.
Then Miss Budnick, so let me know what video you would like me to pull up, and then Miss Fonseca, I think it's 56. You're 56. Then Miss Budnick, okay, this is my 56. I will play it, but I need the screen switched over to my computer. Do you want me to, try to airdrop you these so you can pull them up on your computer? Then Miss Fonseca, this is the only one I'm going to do this way. I'll just...
Whereupon a video recording was played. And
Miss
then
Budnick said, no, shut
the
up.
judge first. The judge says, what number was that?
Then Miss Fonseca, 56 petitioners.
Do you remember? Did you see that? Were you able to see that, Miss Olson? Bree says, yes, I remember seeing that video. Okay.
And then Miss Fonseca, and in that video, did you make a threat against John's mom?
No.
Did you make a threat against John?
No.
Earlier today, do you recall seeing the video Miss Budnick showed of Santos holding W talking about a diss track?
Yes.
Did you direct Santos to make that video?
No.
Were you next to Santos when that video was being made?
No.
Where were you while, I guess, let me strike that. Were you in the house, the same house, where Santos was when that video was being made?
I believe I was outside of the house.
And okay, no, never mind. Strike that. Regarding the kick testimony that John gave on the first day about the labels, do you recall answering a few of the court's questions about how one labels kick streams?
Yes.
And when you make your own videos on Kick, do you get to pick the labels that go on the video?
If I change the title before I start the clip, I'm in charge of it. The clips that come out after the entire duration of the video is done, I'm not in charge of those titles.
So does that mean if third-party clip your kick streams, they get to pick the titles to the video?
Yes.
And in the exhibit that John showed on the piece of paper of your kick titles, were those yours or Clippers?
That was Clippers.
So did you pick the titles to those Clippers videos?
No.
Okay. And leading up to the day that the police came to your house on March 25th, 2025, had you been personally served with an order from the March 24th ex parte hearing? Then Miss Budnick, objection, relevance.
The judge, you opened it up. I'll let her go in. And then Bree, no. I'm lying.
Then Miss Fonseca, how about the order prior to that from March the 17th that mandated the orders or mandated that the visitation be in Texas? Were you personally served with those orders? Then Miss Budnick, objection, relevance.
Again, you opened the door.
Then Miss Budnick, I don't believe we talked about the March 17th order at all. Then Miss Fonseca, We extensively did.
Well, hold on. There was a lot of discussion about kidnapping. I tried to stop it before, but there was testimony that your client was using the word kidnapping. And then Miss Fonseca said her argument was in arguing to his followers that his child was kidnapped, that brought up more. So I'll give a little wiggle room, but not much. Were you served with that earlier order, ma'am? Bree says no.
Then Miss Fonseca, and did you have an attorney at all during the month of March in 2025?
No, I did not.
And when the police came to your house on March the 25th, did you give W to them that day?
Yes, I did.
And regarding the setup of the house of your home, do you recall John and his mom testifying about a hill that leads down from the house?
Yes.
Is that hill a street or a driveway?
It's a one-way street.
So do you recall John testifying that you allegedly directed people to follow him down the street?
Yes.
Is there any other way to exit the one-way street besides to go down the hill?
No, it's one way.
And do you recall watching John's Exhibit 66, where they labeled as you threatening to kidnap W from your visits in Dallas, the supervised visits?
Yes.
Did you make that as a strike that? Were you actually threatening that for real?
No.
Did you have any intention of ever kidnapping your child from the supervised visits with a professional monitor in Dallas?
No.
During the stream on Kick where you were making that comment, was there chat people in the chat?
Yes, they were chatting.
And were they talking about kidnapping?
Yes, they were.
And during that live stream chat, was that your custodial time with W?
I'm not. Yes, it was.
Okay. And to that point, when you had W in LA on March the 25th, was that week, so Sunday the 23rd to the end of that week, the following Sunday, was that your custodial time?
Yes, it was.
I think I'll save the rest for cross, because anything else I was going to ask was going to be about the topics you kind of took off the table after that first day, like the essay, the two gay, all that stuff. Then Miss Budnick, so can I just for clarity, my understanding is there is no cross. I cross and give my direct, and then she redirects. So she has to ask all of her questions now so that I have the opportunity to either cross-examine then or on them or ask my questions, right? Like she can't take a break and then let me question and then start asking about new topics. Then Miss Fonseca, she said this was her direct specifically before the break and that she was not going to ask Brianna anything on direct because she was saving it for mine so we could do a shared setup like we did with John. Then Miss Budnick, that's not how it works.
Okay, hold on. So you have your direct. What she can do is she can take a very broad. I think that the way it works is in terms of this scope, because normally if you questioned, her cross-examination would be limited to things that you covered. But she's also going to do this. She's going to take, my understanding, Miss Budnick, is you're going to address not only the direct of what Miss Fonseca did, but you're also going to use an opportunity to, as if you were going to call Miss Olson on 760, right?
Miss Budnick, right.
Okay. Your redirect based on Miss Budnick's questioning will be to anything that she asks in connection with that cross of you. cross of what you said and then her taking her in for her case in chief.
The Miss Fonseca.
Thank you.
That's
Nancy.
pretty.
That's so pretty. Thank you, love. Oh my gosh, that's so nice.
The Miss Fonseca, yes. And I'm kind of going back to what Miss Budnick said. Maybe it was day 2, day 1 or day 2, where a lot of the exhibits were my clients' videos, but we were trying to lay foundation, ask personal knowledge questions of Dad, when these were supposed to be directed at Mom. So that's her evidence. So I went through some of the ones that the court and her highlighted during the direct of John.
Well, I didn't highlight anything.
And Miss Fonseca, well, I guess the concerning things that the court noted. So specifically because Miss Budnick herself said, "Oh yes, sure, I will reserve this for when I ask Brianna on my direct." Then she kind of today changed that and didn't do a direct and instead is.
Do you think it's appropriate to keep making personal harms at each other? That's not how I litigate when I litigate. And I've said it before, and just before it was, well, it's her video, but she needed to help you. I just would like you all to focus on the issues and stay away from making personal attacks at each other. It takes away from what we're doing here. Issue 1. Issue 2 is, just because it's evidence that she's offered doesn't prevent you from offering it in your case in chief. Again, I'm not telling you how to try your case, but because she has those exhibits in her book, you could go grab that book and in your case in chief, start asking your witness about it. So the only thing I'm asking is, it's your case. You offer whatever you want to offer. If you don't offer something, you take the risk that Miss Budnick asked one question and then you're done, because then it's then if you start asking Miss Olson all these other questions, Miss Budnick is going to go, that's beyond the scope, and I most likely would sustain that objection. So it's your decision. If you want to offer a bunch of videos and ask her to talk about it, now's the time.
And Miss Fonseca, is the court going to let me ask about the DV?
Okay, I am, because here's why. One of the things that, I've been looking at, and I'm sorry, you don't understand what's going on. Oh my God. Sorry. And I'm sorry that you don't understand what's going on. I've been doing a lot of research and beyond what you guys have been doing, just sort of in general, because this is such a unique case. In this sense of, I heard testimony that when Mr. Giese testified that he had Miss Olson blocked. So the only way, theoretically, that some of these messages would come across to him is that there were phrases or comments or something like that somehow or others got into his feed. That's how my 57-year-old brain understands it. So that's an issue, because issue number 1 is even when these statements made directly towards him. So in the context that we're talking about disturbing the peace, and the case law talks about the totality of the circumstances, I'm not sure. That's one of the things I was going to ask both of you potentially. If you have any case law on whether this is subjective standard, whether, he's actually in fear regardless of whether it's reasonable or not. I don't think it is a reasonable person standard, but I think at a minimum, the court has to find credible, right? His claim that his peace was disturbed. So to that, and he's there's been a lot of testimony about panic attacks, throwing up, things about being dismissive, that he was so scared, and this was so awful. Again, not being dismissive, and I think Miss Fonseca has made multiple efforts. I don't mean to be dismissively. She's doing a really good job. I'm trying to understand that. So, do I think, and that's why I didn't get into the whole essay of whether it was true or not, because it was not a defamation case, but it theoretically goes to the issue of whether or not his peace was disturbed or not. If she's accusing him of about seeing other people, and he's admitted that he has been accused, I don't know, but I don't think it potentially might be relevant to the totality of the circumstances. The totality of the circumstances standard I need to apply in terms of whether it truly disturbed his peace. So I'm going to let it go a little bit.
Then Miss Budnick, I do have, I guess, a question.
Yes.
Then Miss Fonseca, in that capacity, because there was a lot of history with respect to accusations back and forth during the relationship. And so I think if we are going to allow lines of questioning about her allegations prior to, these events, do I have the ability to question the respondent about my client's allegations? Because part of this is the reason for the concern right now is because of what
Sure.
Ms. Fonseca happened in the past.
Sure. I think once Miss Fonseca opens that door, you can walk through it. But what I am going to do, I'm going to really try not to make this a trial. And again, I want both parties to understand I am not dismissive of claims of DV, especially when they, not all of them, but those that involve physical force. Your attorneys had agreed previously to sort of move past that kind of. I do think it's relevant because there was an agreement that any future DVRO was going to be based on new conflict.
Then Ms. Budnick, right.
But to the extent there's been a lot of testimony that I was scared, I was threatened, and all of that, I think it kind of goes to the totality of circumstances, but it's going to be very limited. So I'll give you a little bit.
I'm going to start saying like Bree's attorney and John's attorney.
Okay.
Then Bree's attorney. And I would say impeachment because, as you recall from his testimony, I think day 2, he completely denied the incident that I'm going to be asking her about in detail.
Sure.
Then Bree's attorney. So like you said, to totality of the circumstances of saying she's making these allegations or claims online, but her truth is that these are things that actually happened between them.
Well, again, that goes back to the definition. So just so everybody knows, the reason why I'm allowing some DV in is because it goes to the totality of the circumstances, and that is not a defamation case. Yes?
Then John's attorney, just to correct the record, the agreement that was reached in October of 2024 was that petitioner shall have the ability to refile his request for domestic violence restraining order against respondent without prejudice should respondent violate these orders as in the October 31st, 2024 orders. So the understanding was if the agreement set forth in the October 31 order were not followed, the restraining order request that had been filed previously could be refiled, and then obviously the new issues would come out. So I understand that we've been limiting this for the sake of time, but then to my point, I think this does open the door to addressing all of the other issues that were at issue in the prior restraining order request, particularly because I never got into question respondent on those because we settled before she testified.
Well, hold on a second. Let me look at the DVRO, the domestic restraint order application for this DV.
And Ms. Fonseca, and I would like to say that council's
Hold on. Before you go, because if they didn't bring it up in their declaration, it's not fair to then try to, that's a due process issue.
and Ms. Fonseca, if my client's prior counsel didn't bring this up anywhere,
If they didn't bring it up in this DVRO, because if I recall, the application for the DVRO was based solely on and respectively, that's part of the reason why this court didn't grant any temporary orders other than because I was not the judge involved in the prior DVRO. And my understanding was the reason why I did not grant any orders because I wasn't sure, based on the very general nature of allegations about statements made on social media, that they necessarily rose to the level of DV. That's why I needed to have a hearing. Anything. I had seen any allegations of physical violence, and I'm not familiar with the prior domestic violence restraining order application. My sense is that most likely, because those are given, most likely would have granted it, at least the temporary. So again, we are not relitigate. Let me just say it definitely. I am not going to allow counsel to offer evidence as an affirmation basis for a domestic violence restraining order. Any general categories of DV under the DV Protection Act that were not raised in the DV request for DV restraining order file in large. They are potentially relevant to issue raised by your client regarding the totality of the circumstances and why his peace was disturbed as possible impeachment. Now, so that's why I'm allowing Ms. Fonseca to get into that. You may, in defense of that, attempt to impeach the impeachment. But just so everybody knows, it's not going to be a DV within a DV trial.
and Ms. or the Embree's attorney, right, and I will say, into your point about looking for this allegation being raised in the latest restraining order application, it's on paragraph 45, leading page 10 of Ms. Budnick's Exhibit 16 that we received yesterday, which is the DV-100 packet. And one of his allegations is, quote, in March 2025, respondent calls me a narcissistic AB and says he's gotten aggressive in front of my son several times. This is simply false.
No, but there's no allegation that Miss Olson, or no allegation in that Miss Olson committed DV in a physical sense, correct?
The Embree's attorney, no, but I'm saying.
Okay, so everyone listen to me, please. Say it once, and I'll say it again. Miss Budnick seems to say that because we dismissed the earlier one, we reserve the right to bring it again. And my point is, okay, but then those allegations should have been in your request for the DVRO filing in March of this year. They were not. Had they been, I most likely would have granted a temporary RO. I did not. I wanted to hear all of the evidence because this is all about words. I wanted to hear it, and I understand what they do for a living. There's a lot of First Amendment issues. That's irrelevant to everyone. So my point again, I will say this for the last time, is that I think it might be relevant to bring up the prior DV to impeach his claim. But based on the totality of the circumstances, his peace was disturbed. And Miss Budnick may then try to impeach that with other things to say. Well, isn't it true his peace probably was disturbed with whatever? I mean, it's not going to be a trial within a trial. I'm limited. I'm not. I've said all I've said. I think I've made myself super clear. I don't think there needs to be any more explanation. We're all very, very intelligent. Let's go, okay? So you can ask your next question. Let me just say really fast. My peace is now disturbed just from reading this. So
Same.
how are they going to say that that his peace is not disturbed? This is craziness. Okay, I apologize. Go ahead.
Okay, then Bree's attorney. We're back to questioning. Was there ever a physical altercation between you and John when you were pregnant with W?
Yes, there was.
And what date, approximately, month and year, did that occur?
That was when I was pregnant, so it had to have been in 24.
Where did it occur?
In Tampa, Florida.
Were you down there traveling with John?
Yes.
Were you guys in a dating relationship at the time?
It was shortly after our relationship ended.
And where did the physical altercation occur in Florida with John?
It was inside of his car.
And what were you doing inside of his car?
He was driving me to the airport.
So was this at the end of your trip down there?
Yes, it was.
Did you guys get in some sort of disagreement inside the car?
Yes.
What was it about?
It was about a female that had direct messaged me on social media claiming that he invited her after hours to his barbershop.
So you guys were arguing about him interacting with another girl?
Yes.
And how did he...
What happened next? That's the judge.
Then Bree's attorney, go ahead.
After we got in a disagreement about the lady messaging, he got physically violent.
Bree's attorney, and how did he get physically violent?
He slapped me across my face while I was in the passenger seat of his car.
And was he driving when this happened?
Yes, and then he stopped.
What happened after he stopped the car?
He got out of the car.
Were you at the airport when the car stopped?
No, we were in the middle of a neighborhood.
Did he eventually get back into the car?
Yes, he did.
In addition to slapping you, did he do anything else?
It's okay. This is the judge. It's okay. Sorry. Go ahead. What's random?
Then Miss Fonseca, did he put his hands on you at any other point during that car ride on the way to the airport?
Yes, he did.
How?
He tore off the bracelet that I was wearing.
Did you have any, leftover injuries after this incident?
I just had bruises.
Did you document those bruises?
Yes.
Okay, if everyone could turn to Exhibit P, as in Paul, Bates, page 267, do you recognize this photo?
I can't see it.
Oh, sorry, the packet is right there.
Is that the small one or the small or big one?
The big one.
Okay, yes, I recognize this video.
Do you recognize the date on the photo?
Yes, I do.
Is this from your cell phone?
Yes, it is.
Were you pregnant with W on September 13th, 2023?
Yes, I was.
And what is the bruising on your chin? Or strike that. Where did you get this bruising from? Then Miss Budnick, John's attorney, I object. This lacks foundation. She testified about 2024. This is a 2023 photo. Then Miss Fonseca, I'm getting there.
Judge, well, no, hold on. Is this related to the incident or is this related to something else?
Then Bree's attorney, to the incident.
She testified in September of 2023 that he slapped her, and you're showing, wait, no, sorry. You're testifying she's pregnant in 2024. That's a picture of 2023.
Then Miss Fonseca, or Bree's attorney, yeah. So this is the airport ride incident. Then John's attorney, I'm just confused as to time. Then Bree's attorney, did you mess up the date earlier when you... Oh, here we go.
Yes, I did mess up the date.
Okay, so were you in Florida when you were pregnant with W to see John?
Near 2023.
And how did you know that for certain?
By looking at the dates, now recalling.
And is this you in the photo?
Yes.
Did you take this photo?
Yes.
Is this on your cell phone?
Yes.
And where did you get the bruise on your chin?
From John.
And if everyone could flip to the next page, Bates 268, do you recognize this photo?
Can you flip it around because it's upside down? Thank you. That's from the judge, sorry.
Do you recognize this photo?
Yes.
What's the date on it?
September 15th, 2023.
Is this from your cell phone?
Yes.
And what is the photo depicting?
A bruise on my eye.
And how did you get that bruise?
From John.
Okay, next photo exhibit. Same exhibit. Page 269. Do you recognize this photo?
Yes.
Who's in the photo?
I am.
And what's the date on the photo?
September 15th, 2023.
Is this a photo in your cell phone?
Yes.
And what's it depicting?
A bruise on the bridge of my nose.
And where did you get that bruise?
From John.
Last photo in this exhibit. Bates page 270. Do you recognize this photo?
Yes.
Who's in this photo?
Myself.
What's the date of the photo?
September 15th, 2023.
Is this a photo from your phone?
Yes.
Did you ever report this incident to anyone?
I reported it to LAPD and my OBGYN. What? That's who I often report crimes to. Go straight to my
Yep.
OB.
Same. And do you recall when you reported it to LAPD?
Probably about 2 weeks after the incident happened.
Was there a reason that you delayed making the report?
I was traveling at the time, so I wasn't home to make the report.
You weren't home when the incident happened. Okay. And when you made the report to your OBGYN, when was that?
That was probably about 4 weeks after the incident happened.
And was John pregnant at...
Was John... John, you are a talented man!
And was John pregnant at W's birth?
The judge says, I don't think John was pregnant. I think not.
Oh,
God.
sorry. Was John present at W's birth?
Yes, he was.
Did John attend any of the OBGYN appointments with you during your pregnancy?
Yes, he did attend one.
And did you talk to the OBGYN about him attending the birth before he was allowed in the room?
Yes, I did. The judge. Okay, now we're getting way far.
Okay.
Unless it's relevant to the issues of the DV incident.
I do have... Hold on. There might be a video. Okay. Similar to how they introduced videos of her during John's testimony. I do have one video of John talking about this incident that has partial recordings from the incident that I'd like to introduce. Then John's attorney, I'm confused about what incident we're talking about. Then Bree's attorney, this one that she's testifying about.
The judge, the domestic violence.
Then Bree's attorney, and it's him talking about it and recording her as part of the incident.
All right, what's your objection?
Then John's attorney, I'm just still confused as to what.
Okay, why don't you play it? Do we have a transcript?
Then Bree's attorney, yes, it's exhibit CC.
Does she have her own copy up?
Then John's attorney, yeah, the big one. Then Bree's attorney, that'll be Bates page 595.
Okay, whereupon a video recording was played.
Then Bree's attorney, is the recording that John played from that same incident that you just testified about in the car in Florida? Then John's attorney, objection, this lacks foundation. Speculative, she lacks personal knowledge. Then Bree's attorney, she was in the car.
Well, hold on. Hold. No, you are not listening to the objection. The objection is this the same one? She doesn't see it. She hears it. I don't know. Ask, do you recognize that recording that he played in his recording? Bree says, yes, I do. The judge, okay, next question.
Then Bree's attorney, was that from the incident in the car that you just testified about a few months ago?
Yes, it was.
When he was talking about getting out of the car, was that depicting the part that you testified about him stopping and getting out of the...
Oh, wow. This is the judge. Oh, wow.
Then John's attorney, yes.
The judge, this is so leading.
Then Bree's attorney, okay, fine. Okay, is that recording part of what you testified about earlier, or did that recording capture part of what you testified about earlier? Then Miss Budnick, objection, vague.
The judge, counsel, okay, I am trying to be 352. I gave you some wiggle room. I got that recording, and I just saw. It helps me in no way, shape, or form. Clearly, there was some kind of dispute in the car. Whether that rose to a level of DV, I can't tell from the brief part of the recording that was shown on his recording.
Then Bree's attorney, I would say, again, impeachment, because he denied they were ever in the car the second day of his testimony. I think it was. Then Miss Budnick, or John's attorney, I don't know that.
Okay, all right. Whatever weight it did, whatever weight I'll give it in the appropriate. Next question.
Then Bree's attorney, okay. Then John's attorney, I'm sorry, I revisit my objection that it misstates his testimony. I don't recall him ever. Can we get an idea?
Counsel, I'm going to tell you that video helped me in no way, shape, or form.
Then John's attorney, okay, understood.
So just so you know, I don't find them even remotely relevant.
Then John's attorney, okay, thank you.
And that's my ruling. If you disagree with it, you can.
Then Bree's attorney, no,
I think you should move on.
Then Bree's attorney, I was going to ask her more questions.
Okay, great, wonderful. This judge is over it.
I'm over it. I could be a better attorney, and I don't have a law degree.
This is terrible.
Okay, Bree's attorney. At any time that you labeled John as an AB online. What were you referencing specifically? Then John's attorney, objection, vague.
Okay, again, is it relevant to the issue of the totality of the circumstances? Or is it irrelevant to the issue that I don't think is an issue of defamation?
Then Bree's attorney, totally of the circumstances, because he's saying that she was making things up about him, causing him anxiety, causing him to log off, causing him to lose money, causing him to throw up.
Making things up that are defamatory?
Then Bree's attorney, that's what I put in the trial brief as well, Your Honor.
I know, I'm not trying to be rude. I'm really not. I feel like...
Then Bree's attorney, and I'm not trying to be annoying, I swear.
Okay, I'm not saying you're annoying. I'm not. I'm just saying I don't think you're listening to my rulings. This is not a defamation case. There's been so much testimony about defamation and so little testimony about the few things that I think are remotely relevant to their request. So again, it's not a defamation case. It's a harassment and a disturbing the peace as to conduct of DV. So him saying she's an AB or not an AB doesn't matter. It doesn't matter. The reason why I let it in is to impeach the claim of disturbing the peace. The other stuff sounds like to impeach a claim of defamation.
Then Bree's attorney, okay, I think I asked about all of their exhibits, and again, I'm not going to introduce things that we had to counter theirs on topics that the court was clear it didn't want to discuss.
Okay. I mean, if you believe there's things that counter their claim, that there's she disturbed his peace, that she threatened him and she harassed him if you have other pieces that you think, other examples of him saying disparaging things of her, and you want to offer a couple of those things, just like they did, that's fine. I'm not sure it helps me, but...
Then Bree's attorney, we did one of those when he was on the stand. Okay, so exhibit HH.
Okay.
Bates page 612.
Whereas a video recording was played in court.
Then John's attorney, I'm going to object. There's absolutely no foundation that's been laid.
Okay, well, yeah, but she hasn't had a chance to ask her to lay the foundation.
Then Bree's attorney, do you recall when you saw this TikTok clip of John?
The judge, can you put that back because I was looking at the transcript. I just want to see it again. Sorry. Whereupon a video recording was played.
Do you recall when you saw this TikTok clip of John?
In March.
Do you know who he was talking about when he said that?
I would assume me.
Then John's attorney, wax foundation.
Okay, so the way you asked that, she doesn't know for certain. Who do you believe that he was talking about? Bree says, I believe he was talking about me. The judge, and that is based on, Bree says, the date. He said Monday. That was the day that he filed an ex parte.
Then Bree's attorney, and is that Monday the March 24th?
24th, yes.
Of 2025? Okay. Here's another one. Exhibit RR.
The judge, and I will say, from a relevance perspective, I see it was not so much as a defamation issue or lack thereof, but it goes to the sort of totality of the circumstances, whether his peace was disturbed.
Then Bree's attorney, RR is Bates page 639.
Whereupon a video recording was played.
Do you recall when you saw this clip of John on TikTok?
Yes, that was in April of this year.
And how did it make you feel when he made the comment about getting full custody in a state where he doesn't live? Then John's attorney, objection, relevance.
Overruled. It goes to impeachment and motivation. Go ahead. Bree says, it made me feel scared and traumatized.
Okay. Then Bree's attorney, is this the only comment you've seen John make, let's say from March of 2025 to present, about getting full custody of W?
No, it's not the only one.
Can you give me an example of another type of comment you've seen John make to the effect that in that same time frame of March of 2025 to present?
I'm not sure. I'd have to see a video to recall. I can't.
How many times between March, well, we'll say March 24th, 2025, and the present, have you seen John make comments about taking full custody of W online? Then John's attorney, objection, asked and answered.
Overruled. Bree said a handful of times.
Then Bree's attorney, okay, TT, Bates page 643.
Whereupon a video recording was played. The judge, I will note for the record, that was a video. Can I ask a question? Can you put that back up just a second? I'm going to ask Miss Olson. I can also ask Mr. Giese. So there's a TikTok post. Because you both are clearly experts on this issue, where there's two different things of text. There's a black background text with white writing that says, always been aggressive and always had a plan. And then there's white. Then there's a white background with purple writing that says, I think people forget what this man threatened to do before this child was ever born. If you've ever had to deal with legal abuse, you've probably have never spiraled in the same way. So there's a video of Mr. Giese, and then there's two different levels of writing, okay? I mean, only if you know, and I know it's speculation. Do you know where all these actually, and when there's writing on the top, which appears to be a comment from someone, do you know, so is this, can you hit play again for a second to see what it looked like? Whereupon a video recording is played, the judge says, so it looks like there's a picture of somebody holding a phone playing a video. Do you recognize who's holding the phone in that video? Bree says, yes, I do. The judge, who is that? Bree says, John. Oh, the judge, oh no. John's in the phone, but who's holding the phone? It looks like there's a picture of a woman. Bree says, I'm not sure. The judge, it's not yours? Bree says, no. The judge, okay. And then is it your understanding that 2 or 3 sets of people add those additional comments? Bree, yes, it was a clip from his live recording, like live stream. The judge, okay. You didn't make those comments. Bree, no.
Then Bree's attorney, do you recall when you saw this video online for the first time?
For the first time, probably. I think it was before W was born.
Is this the only clip of John you've seen online regarding child support?
No.
How many times since March of 2025 would you say you've seen a clip of him talking about child support?
A handful of times.
Did John in fact take W and give him to his mom?
Yes.
Then John's attorney, objection, wax foundation.
Okay, you do know. Wait, okay, you do know that.
Then Bree's attorney,
Wait,
when did that occur?
No, wait, hold on. That statement's confused me. She says, okay, you do know that. That's what it says. Okay, sorry.
I think it maybe meant to say, how do you know that? But who knows?
I know, but it says you know. Yeah, okay.
Then Bree's attorney, when did that occur in your opinion?
Well, this is the judge. Well, how did you know? How do you know that?
And John's attorney, and also vague as to time.
Okay, what are you talking about? When John took his mom, your child, and gave him to your mom? His mom? When did that occur? Bree says, when he filed for full custody. When was that? Bree says, shortly after I gave birth to my son in 2024. The judge, okay, how do you know? When you say he gave him to your mom, you mean his mom? What do you mean by that? And B, how do you know? Bree says, what I mean by that is handing child off to his mom while he travels, drinks, live streams. The judge, and you know that how? She says, I've observed videos of him traveling and drinking and live streaming during his custody time, and W was not present with him. The judge, okay, and how do you know his mom was watching him? Bree says, I'm assuming that is what his mom. I'm assuming that he was with his mom or either a stranger. I'm not sure.
Then Bree's attorney, on that point, do you recall Mom's testimony earlier about not having your contact information, like your phone number?
Yes.
So if and when John leaves W with his mom, do you have any way to contact her about W? Then John's attorney, objection, relevance.
That goes to mom's credibility. Go ahead. Bree said no.
Then Bree's attorney, so right now, with both of them here in LA, do you know where your child is?
No.
Did John tell you in Our Family Wizard before flying out here where your child was?
No.
Has John ever communicated to you on Our Family Wizard who is watching W if he's not under John's care? Then John's attorney, objection, relevance, this all goes to custody.
The judge, last question, go ahead. What was the question? Question was, does he ever communicate with you on Our Family Wizard where your child is when he's traveling? Bree responds, no.
Then Bree's attorney, okay, the rest of what's on our exhibit list would be as pertaining to child or to custody visitation.
Okay, all right, real quick. You guys we're not, you guys have been so patient. We're on 46 of 67, so it won't take that much longer. Okay, sorry. Okay, all right, real quick, because, and I want to give you time tomorrow, just from like procedurally. So the court is going to rule how the court is going to rule on the DVRO, but then sort of custody and visitation. I mean, I see it's noted as a move away, but some previous judge allowed Mr. Gacy to because he gave him sole legal, right? Is that why the baby would be in Texas?
Then John's attorney, the prior order was primary physical custody to my client in Texas. I believe the parties had joint legal at that point, and then that changed with the March 25th orders, when the court granted sole legal to my client and then made the respondent's visits professionally monitored visits in Dallas County.
Right. Okay.
Then Bree's attorney, but to be clear, the reverse motion away RFO was filed, like within a month of W's birth in 2024. So it's been trailing this whole time.
So it's never, hold on. So the reverse move away really has never been real.
Then Bree's attorney, no. Then John's attorney, so it wasn't a reverse move away when it was filed. W was living here. We filed a move away request asking for W to reside primarily in Texas.
Was that ruled on?
Then Bree's attorney, no. Then John's attorney, we reached a stipulation in October for W to live primarily in Texas. So from my perspective, then Bree's attorney, no.
Hold on, let her finish.
Then John's attorney, there was, not my perspective, there was an order saying that W spent 3 weeks in Texas with my client, and then he was to spend a week in LA with respondent. What we had reserved on was respondent then wanted the opportunity to present evidence on whether W should come back to LA. And I believe that is what counsel is referring to when she now makes reference to a reverse. Then Bree's attorney, on the calendar is still the continuation of the reverse move away RFO that was filed the first month of W's birth. They stipulated to settle the restraining order. The move away was trailed after the original restraining order trial. I keep saying trail. I'm so sorry, guys.
We know what you mean.
Original restraining order trial, which finished by way of stipulation. The move away was never heard, but at our last hearing just yesterday, Ms. Budnick asked about the move away factors and timeframe in which to address those.
Okay, but just so you know, move-aways are the most serious thing.
And Bree's attorney, right.
So I want to manage expectations. I am not going to make a final ruling on a reverse move away on a current move away tomorrow. My sense is going to be, and what my preference would be, look, regardless of how I rule, Miss Olsen is going to continue to have some form of visitation, whether they're supervised or not. You'll hear tomorrow on all of that. It is premature, I think, at this junction it is way premature, I think, at this junction to make any kind of ruling or any kind of final decision that won't even be final on the ultimate move away, because we had this weird situation with the primary was in Texas, and then there was a stipulation, and now there is not a stipulation, and there's so many factors, and the court has to do a written decision on a move away. And a lot of that has to do with the bonding and the relationship between both parties. I don't think it would be fair, especially to Miss Olsen, to then do a move away on the heels of, or a reverse move away on the heels of her now having less time with W in a very sterile and artificial environment. What I would suggest to one or both of the parties is to file whatever you want to file. If it's a permanent move away or a reverse move away or whatever, we set it for an evidentiary hearing. You let some time pass because both of you have some serious work to do on your parenting. I know you have money off of TikTok, and look, but I have heard and seen some really horrible things from a custody, and not from DVRO, from a custody and visitation. So I would like to give both parties the opportunity to be better parents, to be more involved in their children's life, to not be in houses when vapes are being smoked, when kids are around, to not saying horrible things about the other parent, to not being gone all of the time and letting someone else parent or raise your child. Those are all the kinds of things. No, it's not meant for a reaction. So someone must have reacted when she said that. Those are the kinds of things the court will be looking at when I make a more permanent decision. I would like some time to pass. I would like both parties to up their game a little bit and hopefully give me a better picture to look at. So what? So I want to manage everybody's expectations. I am not going to rule permanently on any kind of move away order tomorrow. I think it's too premature. Want to do cross-examination?
Then Bree's attorney, question, though, about the visitation just because of the time. If you recall, the May 2nd order only went through August because we knew we were going to be here.
I am not doing any visitation order tomorrow.
Bree's attorney, okay.
Absolutely.
Bree's attorney, because she was concerned.
Absolutely. Regardless, look, if I grant the DVRO, she's still going to get visitation.
Then John's attorney, we understand that.
If I grant the DVRO, there's a high likelihood I'm going to eliminate the possibility of supervised visitation, even if I grant it. I think Miss Olson has now learned that she has counsel, that not complying with court orders and taking children out of Texas when there's an order is a very bad thing, and she's very public. Mr. Giese and his attorney will find her. They will. So my sense is that she's not going, or that's not going to happen again. Lies. Cross-examination.
Then John's attorney, I do have cross-examination. And then cross-examination, John's attorney. Okay, Brianna, you had just testified. You claim you don't know where your child is right now. Have you ever asked Mr. Giese where W is?
I didn't think I had to.
Side note really quick, I know I'm trying to get through this, but like, even I'm married, and if my husband and child are out and I'm at work, I still like, hey, where are you guys? I have a tracker on my child. Like, I know where my child is 24/7.
Yeah, was she just, he's just supposed to, every time he sees her or they make contact or something, he's supposed to just drop that information? That makes no sense. They don't communicate.
Yeah.
How else is she gonna know? Okay,
Yeah.
let's get through this. We only got 17. It won't be much longer, guys, I promise.
When you are, have you ever asked Mr. Giese via our family wizard how W is doing when he's with him?
He sends me updates. She doesn't ask, he sends them.
The social media clip that you were just shown, labeled as TT, you testified that the first time you saw the footage of Mr. Giese making the comment about, quote unquote, giving W to my mama and paying child support was prior to W being born. Is that accurate?
Yes.
So the statement that Mr. Giese made in that clip predates W's birth. Then Bree's attorney, objection, asked and answered.
Overruled. And then Bree says it was during my pregnancy. The judge, so that's a yes, I guess, right?
Then John's attorney, that's a yes.
Bree said yes.
Then John's attorney, and Mr. Giese has not repeated that statement at any point after it was initially made during your pregnancy. Then Bree's attorney, objection, lacks personal knowledge.
The judge, to your knowledge, have you ever heard him repeat that statement? Bree responds, he reworded it differently, so sure.
Then John's attorney, okay, and you understand Mr. Giese is asking for legal and physical custody right now, correct? Then Bree's attorney, objection, relevance.
The judge, what's the relevance to the DVRO?
Then John's attorney, well, she's trying to make an issue of the fact that he said online he's asking for full custody. He is asking for full custody.
Yeah, that's a good question. Are you aware that he's asking for full custody? She responds, Bree says, yes, I am.
Then John's attorney, and you and Mr. Giese you're both content creators, correct?
Yes.
And the content you create primarily involves what is going on in your prospective personal lives, correct?
Yes.
Okay, and in connection with creating content, you and Mr. Giese both talk about, for example, your parenting and custodial time with W, right? Then Bree's attorney, objection, lacks personal knowledge as to what is influencing John's content.
The judge, okay, in your content, do you primarily talk about your parenting time in custody? Bree says, I'm so sorry, can you reword that? The judge says, yes, sorry, because I don't like to do that. What is the primary content of your social media persona? Bree says, primarily is my day-to-day life, things that I do, things that I eat, things that I wear.
Then John's attorney, what percentage of your content involves John or your co-parenting relationship?
A very small percentage, because, never mind.
Do you create content or share content about your parenting dynamic on a daily basis?
No.
How frequent, how many times do you share your content that has to do with your parenting dynamic?
Did you say, like, how many times a week?
Yes.
Not a significant amount that I can remember, maybe a day.
You were played a recording rather, labeled your exhibit RR, and you said that that was a recording of John from April of 2025, where he says, I'm going to get that money back for my son. You know what money he's talking about? Then Bree's attorney, objection, lacks personal knowledge.
The judge, do you have a belief about that? She says, I'm not sure what money he's even talking about.
Then John's attorney, did you generate income from your Kickstream in between March 23rd and March 25th, 2025?
I did not because I was under management. They received it, not me.
Did your management receive income in connection with your Kickstream from March 23rd to March 25th, 2025?
Yes, they did. And the judge says, but doesn't the money your management receive eventually go to you? Bree says, due to the situation, I did not. They are stealing money from me, which is why I moved and ended management. The judge said, okay.
Then John's attorney, do you have any idea how much money was generated from your Kickstream between March 23rd and March 25th, 2025?
I have no idea.
Impeachment. Can you testify that this exhibit RR was from around April?
The judge, which one is RR?
It was a transcript of the TikTok where it starts with my client saying, because what I said about that house, nah, fuck all that. I'm going to get that money back for my son. It's my son's money.
The judge, okay. And your question was, I'm sorry.
That was a recording that was dated in April of 2025.
Was the video dated in April? Bree answered the same thing. Was the video dated in April 2025?
Yes, or you heard it in April 2025.
The judge, yeah. And I think the only thing she can testify to is what she heard.
Okay, and you heard that in April of 2025?
Yes.
Okay, and when Miss Kesey says, because what I said about that house, do you think he was referring to the MILF house? Then Bree's attorney, objection, lacks personal knowledge and relevance.
The judge, what was your belief?
Then John's attorney, what was your belief as to what house he was referring to?
It was after the March incident that I saw the video. So I would only assume that he was referencing the house that I had just lived in at that incident happened, which, yes, is the MILF house.
Okay, and in that same recording, RR, John says, so, deadbeat dad, where? Better dad, where? Narcissist dad, where? Prior to April of 2025, had you referred to John as a deadbeat dad on social media?
She said, no, you lying. Never mind, sorry. No.
Okay, so your testimony is that you have never referred to John as a deadbeat dad on social media prior to April of 2025.
No, I never mentioned his name during those statements.
Did you allude to John being a deadbeat dad on your social media?
The judge, oh, counsel, show her what you're going to show her.
Then Bree's attorney, I will get there.
The judge, well, we're back in the defamation realm, so the only way it's possibly relevant is potentially for impeachment.
Then John's attorney, well, she's saying she felt scared and traumatized by this recording. That's what she had testified to.
Oh, by that one? Is that what she said?
Then John's attorney, yes.
The judge says, and so?
Then John's attorney, so I'm asking the things that he said in this recording are related to the things that she had said about him. So this recording was the response.
The judge, but it's not.
Then John's attorney, I can move on.
The judge, you can still be scared. and you can still be scared and traumatized and have him saying things that are affirmatively true. She can call him a deadbeat dad, right? Let's say that's true. The issue in that video, from how I took it, were not words. It was the demeanor. It was this sort of hostility and challenging. If you're going to say that about me, where? I mean, so it goes to the essay thing. It goes to the revenge. I mean, it doesn't matter whether it's true or not, because this is not a defamation case. The issue that's relevant from me is the demeanor.
Then John's attorney, okay. You had testified earlier that your social media presence is not necessarily the same person as you are in real life, correct?
Yes.
Do you understand as to whether that's true for other content creators? Then Bree's attorney, objection, lacks personal knowledge.
The judge, oh my God, this is speculation and all sorts of things.
Then John's attorney, I'll move on. You were played a recording that was labeled Exhibit CC that was dated September 10th, 2023, that you said was taken when you and John were in the car together. Is that your testimony that the physically abusive incident you had testified about between you and John occurred on September 10th, 2023?
I'm sorry, wait, what was your question? That was really long.
I think that was let me rephrase. Did the physically AB incident that you had testified about between you and John in a vehicle occur on September 10th, 2023? Is that your testimony?
The judge says, the pictures, look, you testified. The pictures were taken September 13th, 2023. I believe you testified. Those are a result of an incident in the car. Is that what you are referring to? Bree says, yes, I took the pictures after the incident happened a few days ago. There you go. That's the judge. There you go.
Then John's attorney, okay, and did that incident happen on September 10th of 2023? Then Bree's attorney, objection, asked and answered.
Why is the day so important?
Then John's attorney, well, I guess it's not. I can move on.
Okay, I'm going to give you I'm going to give you like 2 more minutes, and then we're going to wrap up for the day.
Then John's attorney, okay. Your testimony is that John slapped you in the face on September, the incident in September of 2023, correct?
Yes.
Okay, and from that slap, you're claiming that he bruised your chin, bruised your nose, and bruised your eye all at the same time. Then Bree's attorney, objection, that's not what she testified.
The judge, she did. She said all of these pictures are a result of the incident. Overruled. Clock it. And then Bree said, okay, sorry. What was the question? Oh my God. Jesus. The judge said, okay, you testified in that incident he slapped you once, correct? And then ripped your bracelet off your hand, correct? Bree said yes. The judge says, okay, so Miss Budnick's question is, the picture that you testified to earlier that that represent the injuries from that incident show a bruise on your chin, a bruise on the bridge of your nose, and a bruise on your eye. So her question is, how is that one slap was able to get you bruising in 3 different places on your face? Sorry, guys. Losing my voice. Bree says, it was a mixture of grabbing and slapping, kind of, all at the same time. I just described it as slapping. It's the easiest way to describe it.
Then John's attorney, okay, and the pictures on September that are dated September 15th, 2023, You took both pictures.
The judge, can you put it on the screen? Sorry.
Yes. Was this picture that you took on September 15th, 2023 at 5:53 p.m.?
She says, has to be. That's what the date says.
Okay, so this other photo that was also attached in the same exhibit that was taken September 15th, 2023 at 5:42 p.m., correct?
Yes.
Okay, and you don't have any red marks above your nose in this photo that was taken sooner, correct?
I do.
Okay, let me see. So we're going back to the photo taken at 5:53, and there are 2 red marks next to your eyebrow. Do you see those?
Are you talking about the one of my eyebrow or my nose?
The ones that are right there.
That looks like a blemish. That could appear at any point. The judge, hold on. Miss Budnick was pointing to, thank you, Bernie. Miss Budnick was pointing to 2. And I don't mean to be rude. What appears to be 2 marks, scabs, something, red marks, maybe bruises, I don't know, above your eyebrow. But then there also appears, I think you said earlier, to be something on the bridge of your nose. So which are you referring to?
Then John's attorney, I'm referring to the 2 that are above her eyebrow.
Okay, this is the judge. Okay, all right.
And this photo was taken again September 15th at 5:53. Those 2 blemishes are not there at the picture that you claim was taken September 15th, 2023 at 5:42 p.m. Are they?
Oh, it's different lighting.
Okay, and you also don't have eyelashes on in this picture, do you?
I used to always rip them off due to anxiety.
Okay.
The judge, let's stop there because we have 3 minutes, all right? So what? Like another half an hour with her, do you think?
And John's attorney, no, I still have to go through the videos that I have of the March 25th incident, so I probably need an hour. Then Bree's attorney, on that, there is 3 clips of over 2 hours of footage. So I would say non-notice because I don't know what clips she's planning on introducing. So I didn't charge my client over $1,000 to sit through over 2 hours of footage. So can she?
The judge, I don't know. I don't understand your objection.
Then Bree's attorney, so she served 3.
The judge, you can go.
Then Bree's attorney, clips that amount to over 2 hours of continuous stream, a stream that was really about 6 hours long for that particular day.
The judge, I thought we talked about, what are you showing her?
Then Bree's attorney, right, I don't know. Then John's attorney, so we had talked. I'm going to show clips of it, but the point is that I sent the entire stream so that she would have it, just like counsel sent me the entire body cam footage stream that was multiple hours long.
The judge, and no one ever showed it.
Then Bree's attorney, I haven't showed it yet because it's her.
The judge, okay, to both of you. Today was supposed to be the end. I rescheduled something for tomorrow. And every time I've been around them, sorry if I've been harsh, but you guys have gone through so much irrelevant stuff that I told you, and then you just keep going over. And then my fear was exactly what we're going to have happen is we are going to run out of time. We're absolutely going to run out of time. So I'm going to say it again. I want to focus all of you. I want to focus all of you because I want everybody to. I don't think I need to see anything that is potentially defamatory. I don't. I've said my piece about that. If I'm in those Oh, if in those stream of 2 hours you believe there are clips where she is saying something threatening or harassing as you think it's defined and protected by the DV Protection Act, then I think you should pick out those clips and send them to Ms. Fonseca. We are going to run out of time. We are. We are, because there have been speaking objections. You guys tit for tat with each other. You make nasty comments to each other, and we waste all this time. And so we're going to run out of time. So, in 2 hours, are there things in there that are relevant to the threats and harassment, or is it just a whole live stream?
Then John's attorney, so it's a very long live stream. She's streaming the entire time, but throughout it, she is engaging in behavior that is harassing.
What specific?
There was a lot of testimony about pewing his mom in the face with a water pew, pewing him with a water pew. There's quite a bit of that.
So I'm going to order you to pick out those clips. Tell Ms. Fonseca what time they are and what clip, and hopefully that's what you're going to show tomorrow.
Then John's attorney, okay. And then there are also I will give all of the portions of the recordings and
the others are?
Then John's attorney, there are other aspects of the recording where she makes threats about him and his mom. There is a portion of the recording where she's being harassing in person as she's walking to hand W over.
Okay.
Then John's attorney, there is behavior that he was viewing on the live stream of respondent with the police in the police presence there with W present. He had testified about his concerns about W being left.
The judge. But that's not the basis of the DV, okay? Again, we are going to run out of time. You didn't have me tomorrow. You're just lucky that I scheduled something. We are going to run out of time, and we still need to deal with the custody and visitation. So again, I would ask, you did a very good job of what I told you of selecting several videos. The fact that we are 2 days into it and we're first seeing these videos that you're saying is a little concerning to me, but that's okay. So select those videos, those pieces where you believe they are directly threatening, directly harassing, those kind of things. Absolutely. I want to see all the stuff about the police. I'm not sure how helpful is that. Wasn't the basis of your DVRO was that she didn't give W over right away to the police?
Then John's attorney, well, we do talk about in the pleadings how this disturbed his peace, how it was upsetting for him, for his child, to be withheld from him. There were officers present. There was a long period of time he was at the house trying to get his son released to him. She wasn't coming out.
Right.
That all speaks to the disturbance of the peace.
Okay. But I think that can all be established in 30 seconds. We've already heard testimony from his mother. We've heard testimony from him that he had to go there. I signed the order. I mean, we've heard all that testimony. So again, we're going to run out of time. I'm going to say that 5 times. She already has. We are going to run out of time. And if she doesn't have the opportunity to cross-examine that or redirect, then I strike everything. So I'm just saying, use your time wisely. We are going to run out of time, okay? I will see you tomorrow.
Then Bree's attorney, but we're not the only ones in the morning, right? Are we morning and afternoon now because our original time was 8:30?
We're still going to run out of time.
But so we come at 8:30 and we'll go.
Yeah, but you probably won't. I would not come at 8:30. I would have you all come about 9:30.
then Bree's attorney, 9:30. Then John's attorney, okay, thank you.
The judge, okay.
Then Bree's attorney, and then we have to do and then we have some of the afternoon.
You have my whole afternoon.
Okay.
But let's say 1:45 in the afternoon because I have one small matter. I'll get them out of here. So please, everybody, be judiciously on time tomorrow. Thank you. The end. Oh my God. I'm genuinely curious. First of all, let me shout you guys out. You guys have hung in with us for 3.5. There's still 1.3 in here for 3.5 hours. So shout out to you guys. Huge shout out to Bailey. I love and adore you. Thank you for always being here. Yeah, if we turn this into a drinking game, you guys would all be like, meh.
I just have a question for AA. Like,
yeah.
At what point can John literally take all of this evidence and submit it and impeach her on everything she said? Like, is that beneficial? Is that not? But all of the lies. I don't know if she's still in here.
They said she fell asleep. She always falls asleep to my lives.
I do too.
You guys, 250,000 likes, 668 daily heart means. You guys are just so freaking amazing. Listen, I always say I think everybody has a profession that works for them. As much as I love law and I love working with my clients in the legal field, I could never do this. I would have snapped. I would not be able to control myself. Every time I feel like, I don't know if this was Bree's attorney's first time trying a family law case, because she seemed clueless as to what she was doing. The judge had to constantly ask the questions for her. I feel like about 50% of that was the judge talking to Bree's attorney about what she can say, what she can't say, how things have to be done, asking the questions for her. That was crazy. That was legitimately mind-blowing.
It really was.
Yeah. Man.
It was, yeah. All right, well, I'm going to hop down. We have to be up at 4 a.m. for a cheer competition. And that's like
on a
5
Friday?
hours away.
Thank you, love.
Yeah. We do a lot of 2-day competitions, so Friday and Saturday.
We used to do it, but it would always be Saturday, Sunday. Well, thank you so very much, love, for coming up and hanging out and staying so late. You would have told me we could have done the rest of it tomorrow, but I'm glad it's over.
Oh no, I wanted to get it over.
Yeah, me too.
I love coming up with reading with you, but I was like, I'm ready to get it over.
Yeah, me too.
No, we travel out of state and we do Saturday, Sundays, but because I live in Utah, where it's very Mormon LDS based, we can't do things on Sunday apparently.
Gotcha.
So Friday, Saturdays.
Well, there you go. We'll get some sleep, love. Thank you. I appreciate you so much.
Of course. I'll be down listening, probably falling asleep.
Sounds good. All right, bye, love.
Bye.
All right, guys. So what do you guys think? Based off of, now we've heard, right? We've heard everything. Not everything, but we've heard the majority. We're still missing a lot from the transcript. What do you guys think? Do you guys think everything is a court bingo? Oh my God, that would be so funny. Do you guys think what they've done so far, like the ruling so far, are just? She's cooked in April. I said the exact same thing, right? Because the judge, or that's what I was thinking, because the judge said, I want you guys to step up your parenting, both of you. And she's walked away from hers, right? I think, I truly believe that Bree tried to pull like a hat trick, right? I'm not getting visits in Texas. Okay, well, I can't get there because I'm pregnant. That means she'll have to do it. And the judge's like, well, then I guess you'll just get the FaceTime calls. That's it. So it's going to move even further away her bond, what little bond she has with W, it's going to move it away. I think it is going to be very, very difficult for Bree to actually try to regain any type of visitation, let alone custody. Especially, let's pretend like Delulu Land, right? Say she really is pregnant. Well, in 3 months, then she's really going to be far further along in her pregnancy. She'll probably be 6-7 months at that point, right? According to her. Then she's not going to be able to travel. So then what? And then she's going to have the baby. Then it's going to be hard to travel with the baby. So she's basically just replacing this baby with another, even though she threatens to delete us the fetus all the time. I agree 100% that she doesn't want custody. And I've legitimately said this from day one. She doesn't want visitation or custody of baby W. She wants to be able to play the victim and say, I tried. Look at all the money I paid to my attorney. I wanted to, but they took it away. John took it away. It's going to be John's fault. It's always John's fault. So, they actually have court in February, and that's for the motion to compel. Yeah, I'm trying to figure out where the high risk thing came from too, because if you guys remember, when they just had an OB appointment, she said they ran out of gas. She's like, oh my God, I've never ran out of gas. This sounds like this is a sign from God that I need to delete us the fetus. I don't know. 6 weeks in a day, remember? 6 weeks in a day. She's been that since like July or August. I don't know. The whole thing to me is crazy. Yeah, and then the whole Paris thing. She can fly to Paris. That's okay. We can do that. No problem. But Texas, no, I'm not gonna do that. Crazy. I'm glad. Listen, I can't wait for this to be over because I'm done talking about it. Also, if you guys were not here on my 1-year live anniversary, you guys voted to bring back a social worker's opinion on. And so I'm going to be doing the first one on the Jenkins, and then you guys can put in the comments who you guys want me to do, and we'll start talking about some new people. There's a ton of other shit popping off on TikTok right now that I'm obsessed with and I'm digging in. I wanted to get this done, and then we're going to start going over it, because this really isn't of much interest to me. So, all right. It's been a long night. Santos doesn't even know what she said. Right. He has no idea. She's got some medication. Yeah, she said that. She got some vitamins and nausea medication. What do I think? About what? Hold on. I like that. Micheline? Is that how you say your name? First of all, it's beautiful. I love unique names. Is it Micheline? But what's your question, love? I will tell you. That's right, the baby aspirin. Don't forget the baby aspirin. Muy importante. I don't know. I would assume that her attorney is going to bring in about what will happen. Okay, I'll tell you. I would assume that the attorney is going to bring in the videos of like the GTA thing. Now, I don't know why GTA was brought up in this at all. I literally have no clue why GTA was even brought up. No idea. And it doesn't really matter, but it does go towards her character and to prove that she's, not trustworthy. So they can absolutely show the video that I just showed. Thank you, love. I love a good night kiss before bed. What do I think is going to happen? I think that John is going to remain having full custody. I think that the move away order is going to be granted, and she'll have her FaceTime visits if she chooses to do them. That will be interesting to see how they go. And I think it'll probably remain like that. I think eventually, in all honesty, I truly believe eventually she's just going to stop trying. She's going to stop showing up. AA said this will look bad for... Oh, absolutely. Yeah, it's going to look really bad for her. I think she's going to stop showing up. Especially if she is pregnant and she has another baby. It's just not going to be worth it to her. So, to her, it seems like if I can't have the man too, I don't want the child type stuff, you know? So I don't know. We will all see. Exactly. She didn't get her way, so she's going to walk away. It's crazy because some people are like, even though we've been wanting to read or hear these transcripts forever, and I'm glad that her attorney put them out, because to get transcripts, it costs about $6 a page. And yesterday we read 103 pages, and today we read over close to 140 pages. So imagine how much money I would have had to spend, right, to do that. But it gives us a whole different perspective inside of the courtroom and the things that she said and how easy and willing she is to lie under oath. Just like when she wrote up her little paper that she just did and just lied and lied and lied and then so casually signed her name under penalty and perjury of law. But she lives with no regrets, and she has nothing in Texas for her, you know? This time, Lily, we got the transcripts because her attorney submitted them as evidence, and that's all public record. Yeah. Actually, all the times we've ever got transcripts has been because her attorney. Even the supervised visit notes, she submitted them. So, yeah. All right, guys. Well, I'm going to wrap it up. I'm losing my voice. I'm exhausted. It has been a long couple of days, but listen, I appreciate you guys so much sticking with me through these long hours and whatnot. Tomorrow, don't forget, we got to kick Shelby's ass. Tomorrow is Shelby and I's first, like we did yesterday a little bit. Thank you, Mama Bear. But tomorrow is our first battle. We're going to do 3 battles a week, just best of 7. So whoever hits 4 first, so that could be 20 minutes. And then I'll go on to regular live. I got a game. I was thinking maybe we could play. But the battle is late. It's 10 p.m. my time. He wants to do like a Shelby Angie like after dark type thing. So if you guys like to do that, I'll be on at my regular time, and then we'll move into the battle later. So we'll be here to hang out and kind of have some fun tomorrow. Get away from some of this stuff. Oh, don't worry. Listen, you guys, make sure you follow me over here because you always get all the correct information. But also follow my YT. I'm not going to go to bed tonight until this is on YT. I'm going to download it over here. It takes usually about an hour. Sometimes it's a little faster. And then I'm going to put it over my YT. Maybe it takes 30 minutes here and an hour over there. But anyways, so in about an hour and a half, it's going to be up. So I will not go to sleep until it is up for you guys. I promise. Okay. I can post the battles, or Birdie, thank you, love. I can post the battles over there if no music's played. YT is weird like that. That you get a strike on your channel. Yep, I'm going to, Jamie, my first video back of a social worker's opinion on is going to be on the Jenkins. So I will hopefully have that up tomorrow. And then you guys will get to hopefully introduce me to new people, right? That you guys want opinions on. Last time y'all put me down, listen, the stress, okay? All the hours of having to listen to the Najums and Gabby and Owen and stuff. Listen, okay, listen, Linda. But I got you. This page is not for me. This page is for y'all. So it's whatever you guys want. That is what we do. Okay. So I'll bring that back. I'll get my first video up this week. I love you guys all so much. Please go get some sleep. I'm going to do the same in a couple hours. I got to get this video up and then I'm going to go to sleep. And I'll be back tomorrow. Oh, I love that, Gloria. That's so cute. Look at all the socks. All right. Love you guys. Have a great night. And thanks again for hanging out.